All right. Good afternoon, everyone. We will have a great presentation today, and thank goodness Rick is taking the wheel on this live stream today. I am doing my best to avoid a migraine. We'll see how that goes as the day and the week goes on, but I'm going to let Rick do this live stream today, and we will uh, let him give his presentation. He's going to talk about the Amicus brief or Amicus brief. I like Amicus. I don't know how everybody else says it, but Rick is going to discuss the Amicus brief that was written and submitted to Oklahoma Court of Criminal Appeals, and uh, was well. I don't want to say they denied it. They didn't. They refused to consider it, basically. So
They
um,
ignored it, is what they did.
yeah, they completely ignored it. And as Rick is going to show you guys today, this was a very thorough. These weren't just some, local forensic scientists or crime lab analysts. These were renowned, world renowned doctors and scientists who contributed to this paper, to this brief. So I am going to first of all say hello to Cherie. I'm so glad Cherie is here, and I'll
Hello.
let Cherie explain why there's two of me and none of her in the chat.
Well, it's hard for me to explain because I don't know. But Rhonda's made me managing mod, but I have some confusion with my StreamYard and YouTube account, so still haven't figured it out yet. So I can be me and still be a managing mod. Maybe someday.
We'll get it figured out, Cherie. I don't know exactly why that's happening like that, but we'll get it figured out. I'm going to add Davey. I don't know if Davey can hear me, but I'm going to add him to. Oh, he can hear me. He just made a beautiful Davey smile. I love Davey's smile. I'm going to add Davey to the chat and let him say hello. And then I need to give Davey a private message in the private chat, and as and then we'll go from there. So, Davey, I'm going to add you to the panel.
Hi
Davey, I'm
guys.
so glad to see you.
I'm so glad to see everybody here. I came to say hi. I saw that the you put up the StreamYard chat, and I was like, I gotta go down and say hi to everybody.
Heck yeah, I'm glad you're here.
See if you needed me for anything, but if you didn't, then we're all good.
Well, Rick's going to do this presentation today. I think you might find it interesting. Hopefully. You're welcome to stay on the panel if you have questions or comments that you want to make. I'm sure Rick will handle that or let you know how he wants to handle it.
Of course.
So
I always have interesting questions.
yes, you do, and that's why that's exactly why, baby. That's exactly why I'm going to put a message to you in this private chat.
Tell me to shut the F up.
No,
I know,
not at
I know.
all. But yeah, I would love to have you stay on the panel if you feel like staying.
Yes.
If you do have comments and questions. Let me just say hello to everybody really quick in the chat. And Muffin Rando is here. Anders is, I believe, still here. I'm so sorry. I'm unfamiliar with your name, Anders, but I definitely appreciate all of those 3 comments that you left, and we couldn't agree more. So thank you for being here, and please feel free to comment and ask questions in the chat as much as you'd like. Kay Bean is here. Just Rhonda 2 is here in the chat. I probably won't be putting much in the chat, to be honest, because typing is just difficult for me right now. So K Bean is here. Rick Donner's in the chat, and more here, more here. Thank you for being here. Again, I appreciate having you in the chat as well. Simple Davy's in the chat. And yeah, for right now, that's who we have. And we're so glad that you're here, and welcome all of you to what I think should be a very interesting presentation by Rick. So,
do I have to share my system audio or just the screen?
I don't know. We can hear you.
Okay, yeah, I don't know when I hit share whether you'll be able to hear me or not, though.
We
Yeah,
should be able to.
we'll figure it out.
Yeah. That's how. This is a very low budget production over here at Just Rhonda Channel. So it's fine.
Off labels, low budget. Also, we just get by getting by.
Yeah, that's it. Yeah, getting by. And hey, Just on, it's so great to see you here. Yeah, I mean, we've only been doing this 4 years now, Cherie, and I still struggle with stuff. So
yeah, in September it'll be 5. I think that's when we started.
5 years.
2020.
Yeah, it's crazy. I think September or October was our first live stream. So almost 5 years ago this fall. So yeah. Listen,
May will be 3 years for me and Biz.
Yeah.
It goes by so fast.
I can't believe it's been 5 years. When Cherie just said that, I was like, holy crap already. But if you go back and watch some of the earlier videos that we did, there's definitely an improvement. I
love to go back to me and Biz's like first shows where like I was just in like a room and I had nothing at all. I had like a was that snowball microphone.
Yeah.
And like it was just me and Biz just shooting shit
and
just having fun. And yeah, it's gonna be 3 years. Oh my God.
Well, we will be there to celebrate with you, business party podcast when your day comes.
And then me and Rich have been doing it for I think almost a year, a little over a year.
Yeah. Time flies when you're having fun. And even though we cover, yours is all political mostly, mine is apolitical and completely focused on mostly Daniel's case. We do throw in some other wrongful convictions as they, warrant news, mostly Richard Glossop, quite honestly. Under Your Scars, it's so great to have you. Thank you for being here this afternoon. But so we do, but that's all. We don't discuss politics at all, other than as they pertain to, in Daniel's case, Black Lives Matters. And, no matter how hard I try to keep the politics out, that I can't keep that out because it was a part of his, trial.
Unfortunately, with some of the things like that, you can't keep the politics out because politics are a big thing nowadays, dealing with police matters, dealing with civilian matters. Like it's all political. Like we were talking about,
unfortunately,
like the January 6th, the Jan 6 guys, like it was all political,
we can't, Davey, no.
Oh, sorry.
I'm out.
My bad.
That's okay.
My bad. I was just trying to say, like, everything is political now. Like, no matter what,
everything's
no matter what you talk about,
it
it's all political, and it sucks. It really stinks that it has to do with politics for everything. Like, if you go to jail for something like Daniel, it's all political, it's all racial, and all that stuff. And it's no longer cut and dry, and that's what sucks about
There's
it.
no separation, it seems like, anymore, and I don't like it. But on the bright side of that, I shouldn't say bright side, but on the other side of that, Daniel's case, began in 11 years ago, and almost 11 years ago. He went to trial in 2015. He was convicted in 2016, and then the appeal was in 2017. Well, filed in 2017. So as far as Daniel's case, it's not political. Well, it's not forwardly political anymore, I guess is the best way to say that. Um, the the fact that he's still in prison, we can argue is, definitely could be some politics involved in that. I honestly don't know, but at any rate, it's just it's hard. So, but with Daniel's case, other than the Black Lives Matters and the protests and things like that during his trial, we don't really have to bring in too much politics. I know I keep saying this, but at some point, when I get more organized, I don't know when that's going to be. I really am serious about starting a second channel, and then we can have more potpourri, is what I call it, potpourri type topics. And if politics comes into something that I do, then it does, because I'm not going to limit anybody's free speech in that way. But but not for this channel. That's just always been very important to me, and Cherie and I have agreed on that from the very beginning. So I hope everyone respects our decision with that. If not, I guess it's not my problem. I guess if you don't appreciate that. But as far as anything that you want to say about Daniel's case or anything related to Daniel's case, I'm not going to stifle your free speech in that way. But unless it starts, getting really crazy about political things and sides and red or blue or left or right, I'm not going to allow that to happen. I'm really sorry, but not in this channel. So anyway, excuse me. I'm going to send you a private chat, Davey. I'm so glad you're here and on the panel, and you look a little better than you've been the last month or so.
I feel,
and I hope
so much better.
That's what's important.
I feel so much better.
Good.
I'm better. Like I said, me and Richard had a talk after a show, and he kind of said the same things that my wife said to me, and kind of put me in my place. And I was just like, okay, you when you and my wife say the same things without having conversation, because Rich and my wife don't talk. When you and my wife say the same things, it kind of brings you back to life. And I'm in a place where, like, and I spoke to my wife about it. Like, I was always the breadwinner for everything, and I feel that pressure. You know what I mean?
Mm-hmm.
Like, I feel the pressure to be the man. And I had a conversation with my wife, and my wife was like, "Listen, you don't have to be. You can go get a job at McDonald's if that's what makes you happy." And yeah, and it's I feel a lot better. I feel a lot better. I'm,
and that's obviously that's good for your health, because I'm not going to spread your business, and we need to get started here. But for those who don't know, Davey's been struggling with some severe heart-related issues. I guess I'll just leave it at that. Yeah, okay. So yeah, he's wearing a heart monitor. He's too young to be having, way too young. I call Davey my virtual son because he's that young. So
it's just the business I'm in. It's a toxic business. It's a toxic business, and but yeah, no, well, I'm a lot better now, and
that's good.
I feel better.
That's good. And hopefully, you probably don't remember them, but I know that I sent you, in different chats, or maybe even on Rumble. I told you, no job, nothing in life that you can control is worth risking your health over. So anyway, okay, Davey, glad to have you. I'm going to send you a private chat in a second. And at this point, Cherie, do you have anything else you want to add or discuss before we get started?
No, I'm ready to go.
Okay. All right. We're going to let Rick. Rick has a background in a lot of different areas. And so he is going to present to you some information about this amicus brief. And so, Rick, whenever you're ready, I will let me let me make the screen so that you can figure this out. Does that work, or do you need us smaller? Or
No, that's fine.
okay, all right,
As
we're
far
going to
as I
let Rick.
know, we're going to
Yeah,
find
we'll
out
see.
here in a second.
We'll see. We sure will see. Okay. All right. I will mute and let you
Okay, it's not
go
coming
ahead,
up.
Rick.
Why?
I needed to add it to the
Ah,
stage. Okay.
there it is.
So, yeah, um, you need to, because
Okay,
I'm
you
sure
all
you
are
don't
going to
want the
have to tell
chat.
me where. Oh, I don't mind the chat being there as long as people
Okay.
can read what I'm sharing on the screen and see it.
Okay.
Actually, I can
Okay.
move that because I have the
Oh, there you go. Oh, look at you. It's up to you. I don't. It doesn't bother me either way. Okay. Or
normally
you.
during streams I keep because I have to pause the video on YouTube. I put the
Oh,
chat from YouTube there because it's easier for me to see, but
okay. So, can you see now what you have on your screen, and you can point and all that stuff? Oh,
yep.
okay. Perfect. That's all we need. So I'm going to let Rick take over. Let him kind of give him, his own kind of
Well,
introduction about.
quit clicking on it and let me just see it. Okay,
I'm
there, I
not
got it.
touching anything.
No, not you.
Oh, okay. I was like, I'm not touching anything. Oh gosh. Okay. All right.
No, not
Rick, whenever you're
you.
ready.
Uh, oh, okay. Rhonda asked me to actually, I volunteered to go through this, and Rhonda was ecstatic because she's like, yes, please, somebody that understands this. This amicus brief was written when she says world class, world class. These people that wrote this are the ones that wrote half the books on forensic science. And I'll give you their names as we go through this. I'm not going to dig deep into their CV because it'll take forever just to do that. One of the reasons she was happy when I volunteered to do this, a lot of people don't know, I don't talk about it much. I actually have a PhD in molecular biology. That is one of my degrees. My particular area of molecular biology is not forensics, but I know enough that by reading this, I can understand what they're saying. Um, I got it because I also have a degree in astronomy and I'm real interested in exobiology, finding life on other planets and stuff, which is why I got it. So, um, this was filed by this panel as if for anybody that doesn't know what an amicus brief is, amicus is kind of like a friend of the court. If you watch Robert's stream, you hear him talk about it all the time. It's basically an interested group that's following the case or has studied the case that goes, oh, we think it's important for the court to know this information, so they file an amicus brief for the court to consider as part of their decision. Um, Starting with their introduction, uh, one of the reasons they took an interest in this case is because they helped set the standards for what a forensic lab should be. And it's very obvious from reading this that the forensic analyst that worked on this case did such a haphazard job that you really can't trust any of her conclusions. And I will show you things that will explain why I've broken it down into a little bit easier to understand language as we go through this. You're going to see a lot of big words. Don't worry about it. Don't try to Google search them. You can if you want, but I've broken it down in a way that's going to be a lot easier to understand. Okay. Hang on a second. I'm just adjusting something here so I can actually see the screen move in the stream. All right. If anybody has any questions along the way, please feel free to ask them. I'll do my best to catch them while I'm going through this and answer them. I don't want you to feel like you have to try to remember something for when it's all done. This is basically an introduction to the court saying who they are, why they're writing this. The important part is where it says in view of the panel, DNA evidence was misused, and that's very important. They're not saying may have been misused. They're saying it absolutely was. And that's what led to his conviction. Dr. Peter Gill is on this panel, Jane Goodman, Delahunty, Susanna Ryan, Moses Shanfield, who, by the way, Moses Shanfield, he was on my dissertation panel when I got my PhD. He was one of the ones that sat on the panel for my presentation.
Wow.
George Shiro, Brent Turvey. These people have a huge, I mean, just look at Brent right here. Criminal profiling, forensic criminology, forensic victimology, forensic science, criminal investigation, criminal justice ethics, miscarriages of justice, law enforcement corruption, all of which came into this. Okay. Part of the problem with this case, especially concerning the DNA evidence, I'm sure everybody knows of or has watched things like NCIS, CSI, CSI Miami, CSI New York. If you're old like me, back to Quincy years and years ago, where they gave presentations on different forensic or used forensic science in the as part of their shows.
It's murder, Sam. Murder.
Yeah. Americans have gotten into a psychological culture of, oh, if the forensics people say it was this way, it has to be this way because all these shows portray it in a way that says it's never wrong. Every now and then CSI, what the original CSI would go, yeah, we got that wrong. We discovered it actually meant this, but those were few and far between. So the American public has gotten into, it's called, the technical term is confirmation bias. You expect it to be correct, so you believe it's correct whether it is or not. And prosecutors use that confirmation bias to skew the scale towards their side of the case. These people on this panel are like, hey, look, courts, regardless of what the prosecutor or the defense does, the court itself, which means the judge, has to be extra vigilant because you can really mess somebody's life up if the prosecution misuses this information. They talk about that confirmation bias. They call it the aura of conclusiveness, which is there again, watching all these shows. They have come to the absolute conclusion, looking at all this, that the DNA evidence in Daniel's trial was absolutely misused. It was related wrong by the forensic scientist who testified. It was misused. That information was misused by the prosecution. And there is a part of this that is very important. I don't know Daniel's first lawyer. I don't know a whole lot about him, but they came to the conclusion that his defense counsel absolutely deprived him of a fair trial by not challenging all this at the time. And correct me if I'm wrong, but didn't his attorney have some outside forensics person look at this and then never used him as a rebuttal witness?
Yes, that's true to my understanding. Yes.
Yeah, I thought so. Mistakes
And if
made.
I'm sorry,
Yeah, go ahead.
I was just going to say, and if I'm not mistaken, I believe in Daniel's appeal that was used as part of his ineffective assistance of counsel. And yeah, but of course, that denial letter is probably something else we need to also maybe next time around go through, because it was pretty crappy. So
Yeah.
Anyway,
I agree with their conclusions in this brief. The problems forensically started from the moment they started collecting evidence, specifically Daniel's uniform.
Can I say one thing real quick?
Mm-hmm.
Tony Hay with the members for 5 months. Thank you very much, Tony.
Thank you, Davey. I was just going to say something as well. Exactly. Yes.
Listen, I always have to say that. That's my
You do,
thing.
and that's fine. I'm sure Rick's fine with that. Cherie will be fine with that. It's all good. Thank you.
If anybody has watched my facial expression in previous streams when we've alluded to the DNA evidence, you'll know what I think about it. The collection of evidence was screwed up from the first second. The absolute first second.
Yeah, of course I agree.
Yeah. They also raised the point in this that because of the way it was misused in Daniel's case, it has broad implications for other cases. If you let one court get away with this, then every other court is going to get away with it, and these people are going to continue to misuse it.
And Rick, I don't know how much research you've done in the history of OKC and Crime Lab and PD and all that stuff, as far as DAs go, but Cherie and I have researched this for almost 5 years now. And the thing is that they have gotten away with it for so many decades that it just added to how they were still able to get away with it now. And in Daniel's case, because there's the crime lab analyst who was Elaine Taylor's supervisor initially. Her name was Joyce Gilchrist. They called her Black Magic. Anyway, she was full. Her crime lab, her testimony, her ways that she conducted, forensics and analysis and all that stuff. Years and years of corruption on her part, and you know, coddled by Bob Macy, who was the DA at the time. They were like hand in hand, corrupt in some of their cases, and in some of a lot of the forensics that she did, going way back, way back. And she was ultimately, after it was too late, I mean, she had men on death row, at least one that she sent to death, well, that Macy sent to death row based on her analysis, who was ultimately executed, who was shown to be, after the fact was evidence proved that he was actually innocent.
Yeah.
So anyway.
But
for anybody who's ever taken a statistics class in college, one of the first things you learn in stats class is you can take the exact same set of data, and by using a different skew number, you can make that data say two complete and opposite things. All you have to do is change one data skew, and you can make it say exactly the opposite of what it is you're trying to use it for.
That's the problem though with all this stuff, like with politics, is like they're just trying to further their career. So it doesn't matter if you're guilty or innocent. If they have statistically, if they have more wins and losses, they think they're better. And that's the problem with this.
Unfortunately, in especially in the United States, not just the United States, but other countries as well, the justice system has changed from a search for the truth of what really happened to how many wins can I pile up to make my resume look better.
Yep, and that's what's wrong. That's what's wrong with it.
The better my resume looks, I can go from local district attorney to attorney general to working for the Justice Department. And, so I need to have that buildup of wins on my resume. And we've lost the whole purpose of the justice system at this point in many ways.
We've lost the plot. We've lost the plot at this point.
Agreed.
Okay. I'm not going to try to read this whole thing word for word because it's like 62 pages. So I'm purposely pausing so people can read this as I talk. Pay particular attention to the things I highlighted in red and green and blue, because that's where they're really making a point.
And Rick, just for those who aren't able to see it very well on the screen, on their YouTube screens, can we do an upload of your what you're using now with all of your highlights and things for people to read on their own? And
yep,
if they want to. Okay, all right.
Yep.
We'll make that available for you guys.
Yeah, I'll put it on the Discord server.
Okay, thank you.
I'm sorry. Nobody caught K Bean's comment on the side about.
Yeah, I saw it. Statistics equals
did.
lying with numbers. Yeah, I saw it.
I don't think that's the one he's talking about. No?
Oh, no, I did not catch that one.
Oh, Davey. Are you talking about K Bean saying Black Magic was her stripper name?
Yeah, I was. I looked over and I caught it, and I just fucking. That's why I've been laughing for the last 2 minutes.
Okay, I'm not going to try to go through all of the facts of the case, but I highlighted some things that are important. Okay. On the afternoon of June 18th, the sex crimes detectives, one female, the other male, interrogated Daniel, Mr. Holtzclaw, for approximately 2 hours. This is where the mistakes start. This is why I said from the first second, handing him pens to fill out forms.
I'm sorry, I was trying to help you. I don't know how to make us smaller and you bigger.
This is very important because now there's a possibility of their DNA, and remember, one of them's a woman and one of them's a man. There's a reason why they pointed that out. Could now have transferred their DNA to Daniel's hands. They hand him a pen. They don't have gloves on. Watch the interview tape. Neither one of them has gloves on. They never do. So now we have a possible transfer of DNA, male and female. At the end of the interrogation, the male detective inserted his bare hand in an evidence bag, into which Mr. Holtzclaw then placed both his his navy blue uniform pants and black Velcro belt in the keepers. If you watched a previous stream, I talked about the fact that she would have heard the Velcro. Only Mr. Holtzclaw's uniform pants and belt were collected as evidence. Now, we're going to pause here for a minute and going through this. Let me explain to you exactly how it should have happened. First of all, there should have been more than one bag. If they were collecting 2 items, they should have had 2 bags. You never put more than 1 item in a bag. They should have had Daniel remove them, had a clean sheet of butcher block paper, have him put his pants on that paper, fold the paper around the pants, and then with gloved hands, open the bag and put the pants in the bag. Same thing with the belt. The actual standards for collecting clothing is to have the person remove it, wrap it up in clean butcher block paper, then put that wrapped up package in a clean paper bag. You certainly don't put ungloved hands in a bag and not wrap it up. Oh, we're gonna get to that, K-Bean. Trust me. Okay. The OCPD forensic analyst observed nothing suspicious on the fly of the uniform pants by using a very bright light and magnifying glass. She did not test the uniform pants for body fluids or use an alternate light source to identify whether latent stains were present. And everybody goes, okay, first of all, if you're using a bright white light, you're not going to see it. If there's anything there, remember, it's been hours. Okay, there it goes. This is a photograph of actual examples of body fluids that were photographed under an alternate light source: saliva, semen, and urine. If she had just used an alternate light source, as the standards require, she'd have been able to easily see if anything was there or not.
Can I just make a comment?
Mm-hmm.
Do you think it's possible, and I'm just throwing this out there because I feel that this case is so corrupt from start to finish, well, start to now. Do do you think it's possible that, we've already explained all of the relationships between Elaine Taylor, the crime lab analyst, and to Rocky Gregory, the detective who shoved his hand in the paper bag, and all of those things, and other connections that it's a crime lab that's connected to the police department. And so, do you think it's possible that Elaine Taylor may have used the alternate light source, perhaps, and was afraid, or was maybe coached, or it was suggested to her that, okay, well, we see something on there, but it might not be who we want it to be. So we're going to just say that you didn't use the alternate light source, which makes her look slightly incompetent, in my opinion. But do you think it's possible she did and then wasn't allowed to say or admit it? Okay.
Nope. Okay. The one part of that crime lab that I went on a fairly deep dive on was Elaine Taylor and her education and background. I don't think she used it. I don't think she ever used one in any case.
Okay. And you're right. She wasn't. I'll have to find it, but I think there's proof or evidence somewhere that the certifications, and maybe Cherie might remember this as well. I'm sorry to keep stalling you, Rick, but I feel like somewhere there was evidence or proof or something when you look at Elaine Taylor's certifications and things, that she might not have been as educated as she claims. I don't know. Do you remember anything like that, Cherie?
I remember that she didn't have much training, other than, like, she didn't do that well on the classes she took during her education. And then, they get the trainings afterward. But
yeah,
you have to look at who her teacher was.
Right. Exactly. Yeah. I don't know. I'll do some more. I'll go back into my old research and see if I can find anything like that. I could be wrong about it, but like Cherie said, she wasn't. Didn't do as well as she claims.
I know she was not anywhere near the top of her class during her education. I never found any evidence that after her initial education and certification, she ever took a continuing education course. She never took an update course that I was able to find on new techniques and stuff that had come out. I was never able to find anything showing that she tried to keep up with standards and techniques as they changed.
Okay, got it. All right, thank you.
I'm sorry. I have to turn my camera off because K-Bean is just making me.
Davey,
yeah, I'm trying.
My face.
I'm trying very hard not to look over at the chat right now.
I'm sorry.
Listen, Davey is like in his 40s, if I'm not mistaken, but I'm
an 8-year-old child. I'm an 8-year-old child, and for me, with my face, I can't. I'm one of those people who have a face that tells everything. So, like I said, I'm gonna turn my camera off. I might have to go because I'm trying to hold back.
Davey. Listen, and I'm not stifling anybody. I mean, you guys are naughty. We've, maybe not Cherie, but we've all been naughty with comments and things like that. I'm not stifling your speech like that. If you, say what you guys want to say in the chat. Be naughty or whatever.
I know, but this is like it's a serious topic, and I want Rick to tell all his knowledge, because Rick is very knowledgeable. But I'm looking over at the chat and I see certain things, and I'm just an 8-year-old boy.
Gosh.
It's good for us to laugh now and then, I think, because what we cover is very
Well, that's why
somber.
that's why I wanted to come on here, is because you guys cover very hard topics and very serious topics, and sometimes you got to throw in a DNA mouth joke or a stripper joke just for
Davey,
laughs.
You're right. And K Bean said something like that earlier in the chat. K Bean, I want you to be yourself. I know who you are. Most of us in the chat and, everybody on the panel, maybe Cherie a little less, but we all know who you are and how you are and how fun you are, Davey as well. But listen, if it was just me, I would be fine. But Rick's put a lot of work into this, Davey.
I know. Yeah.
To get to the serious side of it, Davey, I know you're laughing at K Bean's joke, but she actually made a valid point that is a part of this presentation.
Yeah, she has.
So I'm loving the fact that she's bringing stuff like this up in the chat, because you're going to hear about it later.
Yeah,
and
they're valid points.
That's why I love the chat, is because, and even with our show, everybody makes valid points, but everybody's also makes fun of things. Yeah. But everybody also makes very valid points, and that's what I love about our chat.
Right. And it's like Cherie said, Cherie and I have been covering Daniel's case for 5 years almost. But before Daniel's case, we were very, very involved in, and I don't know who was familiar with this case or who isn't, but we were also very involved in Stephen Avery and Brendan Dassey cases from Wisconsin, who we believe are both wrongfully convicted.
Yeah.
So we've covered, and that case involves a murder. So a very gruesome murder.
Those cases are insane. Those cases are crazy.
So
and I've started deep diving into a Navy sailor that got wrongfully convicted of something.
I'm going to say my goodbyes, and I appreciate y'all having me, but I can hear the baby crying, and I know Amanda is tired.
Go love your baby. Go take care of your baby.
Love y'all.
Davey, thank you.
You guys are
Keep
the fucking
brother.
You guys are the freaking best. We love you guys and we appreciate y'all so much.
We appreciate you too, Davey. I love you. I love your guts. Okay. And K Bean and Lauren, hi, it's great to see you in the chat. K Bean, be yourself. It's fine. I'm not, it's, I'll just say this out loud. I believe, based on an excellent source, that Daniel's mom watches some of these live streams, not necessarily live as we're doing them, but I believe she's watching. I believe she watches them at some point, and I've spoken with her about it and apologized for my own crudeness at times in live streams. And she's laughed with me and told me, she doesn't take offense to it, any language or things like that, and to keep doing what I'm doing, keep doing what we're doing. Even though she said that to me, I still have. I'm a mom of 5 boys. And, I listen, because I have 5 boys, I have the mind of a teenage boy, kind of like Davey. But I do try in Daniel's case, because it's so heartbreaking for them. I do try to not, and the things that they testified about him in the trial, I cannot, in my wildest imagination, I can't imagine sitting in a trial or anywhere publicly and listening to those horrific things about one of my sons. So I do try, and I'm trying to be better, not to be as vulgar and vile and foul. But listen, in the chat, knock yourself out. I'm not coming for anybody in the chat for, being naughty or, making crude comments or anything like that. So just be yourself and stop holding back, KB. Don't hold back. Just be you and say the things you want to say. I'm not deleting any comments. I don't have any mods that are going to come in and time you out or anything like that. So you're fine. I just want to make sure that you guys know that, everybody. Okay. I'm so sorry. Rick, please
No,
carry
you're
on.
fine. Proceeded directly to swabbing only the outside and inside of the fly of Mr. Holtzclaw's uniform pants for DNA. K. Bean, this goes back to a point you made earlier. His DNA should have been all over those pants. They never tested anything but the material right around the zipper.
That's right. I've shown pictures of that before.
Yep.
I mean,
Yeah,
I won't do it now, but I'll pull them up and we can look at them later if you want, or unless you've got them.
No, I didn't make him a part of this.
Okay, that's fine.
They never tested in his pockets. They never tested the pant legs. They never tested away from the zipper on the interior or the exterior. All they did was test around the zipper. The forensic analysts obtained 4 DNA samples, 17Q1 and Q2 in June of 2014. This is important. And then Q3 and Q4 more than a year later. Why all the time between the samples? Why wait? By vigorously rubbing wet cotton swabs up and down the full length of the fly of the uniform pants on 4 different stretches of fabric alongside the zipper. The outer left hand of the fly and inner right hand fabric flap that is revealed when the zipper is unzipped, and 2 interior stretches of fabric to the left and right of the zipper. Why did she not take those samples all at the same time? That makes no sense. The only forensic evidence linking Holtzclaw to any of the complainants in the entire trial was a DNA profile ultimately matched to the teenager Ms. C1. Well, he never said he didn't interact with her. It could have been simple transfer of DNA, innocently transferred. The OCPD forensic analyst testified that Mr. Holtzclaw was excluded from being a contributor to all 4 DNA samples when in fact the data were inconclusive. Okay. Now we're going to go over to this chart. She's saying he was excluded. This is a chart I made based on the actual chart that was put in evidence in the trial from the forensic analyst report. Please don't try to understand this chart on your own. This is where I alluded to putting things in simple language so that people can understand. You'll see the 2 column headers that I highlighted in pink. These numbers mean stuff to the people that work in this field. Here's how you actually come up with those numbers. The D8S1 1179, the D means it's a DNA sample. The 8 means you isolated the 8th chromosome. There was a single copy of that chromosome that you obtained. The locus number is the area on that chromosome that gets assigned for where the material came from. The TH01 refers to a sequence. It's called the tyrosine hydroxylase gene. Basically, it's on chromosome 11. Basically, we refer to it as a DNA fingerprint because it is different for every individual. The easy explanation of what the tyrosine hydroxylase is it's an enzyme that causes your body to start producing things like dopamine. It triggers L-DOPA production is what it does, and what L-DOPA does is makes your body create dopamine or norepinephrine or epinephrine. It's part of the system that creates a flight or fight instinct. It also helps you fight allergies, which is what norepinephrine is.
Oh, I need more of that norepinephrine stuff. I need it in an IV drip.
Okay. The VWA that I have here in the yellow, it helps create a unique DNA profile for an individual. It's one of the easier ones to isolate to try to separate out an individual, especially if you have mixed samples, one individual from another. And then TPOX. The TPOX is short for tandem repeat locus. Basically, that number indicates how many repeats of the AATG sequence there is in a sample. And if I come down here, I've got this red arrow right here. This is an actual genome map from a human biological sample, and you'll see AATG right there. What that number in her chart is saying is how many times that repeated. So in this particular one, there's one right there. Now, if I tried to show this entire genome map, nobody would ever be able to read it on the screen. So I isolated a part of it where there was one at. Okay, so in Daniel's case, 8 and 11. They found one at 8 and they found one at 11. Remember back here, D8S 1179? That's 8. Okay. The THO1 is 11. So they found repeats at 8 and 11 of that AATG sequence.
And that's on Daniel's line, right?
This is Daniel's.
Okay.
Yeah, sample 19A, that's Daniel's.
Okay. Yeah. Okay.
Okay. The AMFI. This is another one of those that can be very specific to an individual and link them to a stain, which is interesting because she never found a stain. So how is she linking it to the stain? Okay.
Because she didn't use the alternate light source. Is that what you mean? Or
Exactly. How is she running something that links to a stain
that she
when
claims she never found?
she claims she never found a stain?
I guess that's what, because I've contemplated that before, and I guess that's why I asked the question I did earlier about, do you think it's possible? But if the two don't connect or don't, correlate together, then I guess but anyway, that's
Yep.
kind of why I asked that question, I guess.
Okay. Now I'm showing you this chart now to set up how they're realizing that she screwed all this up. not used for statistical calculations. Well, what does that particular thing happen to be? The locus amelogenin. Excuse me, I think I'm going to sneeze. Maybe not. No. The locus amelogenin it refers to a specific region of an XY chromosome. What this actually does is believe it or not, it's part of the DNA that's crucial for your body to produce enamel for your teeth.
Interesting. Okay.
Okay. But there's different versions of it depending on whether you're male or female. So it's one of the ways that you can get a quick readout on whether that DNA is male or female. If you look at osteoarchaeology, where they find skeletons in the ground, they'll remove one of the teeth and get a DNA sample from it because it's the quickest way to determine DNA wise, especially if the pelvic girdle is not with the skeleton, whether or not the remains are actually male or female. Alleles below stochastic threshold locus not used for statistics. Well, what is stochastic? From the Oxford Language Dictionary, randomly determined. So what this forensic scientist did was went, oh, I've got all this random DNA stuff, but this is where I have the threshold for that being valid, and I'm going to say that that material was below that threshold, so I'm not going to use it. So there may have been genetic material and results in those samples that she just threw out and never used because they were below the threshold of what she used to compile her statistics. Regardless of what the results of them were, that, yeah, they're below my threshold, so I'm not going to use them.
Yeah, that's always, I mean, I know it has to be, I understand that has to be a thing, this stochastic thresholds or whatever that's called, but shouldn't that just be a standard though across the entire board?
There is a standard nationally.
Okay.
The Oklahoma City PD Forensic Lab didn't use the national standard. Each individual forensic scientist used their own standard for what that level is.
So that's not uncommon then that
Unfortunately, no, it's not uncommon for them to do that. That's why these labs have got to be held to a national standard.
So do you know whether a lab would set, okay, in 2020, we set the standard at whatever, 14, I guess. But, do they change that then, well, we don't want this to show up, so we'll say it's, or do you know what I'm saying? Like, can they just randomly change that?
That's exactly why these labs don't follow the national standard. Each individual forensic scientist sets their own threshold. It's a way to manipulate the data to say what you want it to say. These labs should be forced to follow the national standard. We have national standards for all kinds of different industries and parts of our society that everybody has to follow. And if you don't follow it, you get in trouble. The national speed limit. Back when they made the national speed limit on interstates 55, that was nationwide. If you didn't follow the federal standard for the speed limit, you know, if your state decided we're not going to do it, okay, you're not getting Department of Transportation money to keep your roads up. If the drivers didn't follow it, okay, you're going to get a ticket for going over 55 no matter where in the country you're at. Forensics labs are not forced to follow the national standard, and they should be.
Yeah, especially when people's lives are on the line, you know, because of DNA. I mean, this is probably not a fact, but it's a thought that I have. There is so much now that let me address this really quick. Joffrey, it is so great to have you in the chat, and welcome back. It's been a minute since I've seen you. Rick has all of the same qualifications and experience, and
not all of them, but
well,
a lot
enough.
of them that are similar. Yes.
Yeah, absolutely, and definitely qualified to talk about this with us. So yes, and I'm so happy to see you, Joffrey. Okay, sorry, Rick.
No, you're okay. Okay, couple of other things I want to point out here, and we're going to do these in yellow. One of the things that I believed, and I think that from reading the panel's brief, I believed here is why the jury got confused. Going to look at Daniels here, you see all these numbers right here. Okay. The only thing, and let's change colors for this. The only thing that's different from any of these female so-called victims on this chart is this right here. Clearly showing
Right,
he's a male, XY.
Yeah, male DNA, correct. Yeah, okay.
Okay. This column, 13, 13, 13, 13, 13, 13. And if you go through each individual column, you're going to see some matches to Daniel's number. 30, 30, 30 is down here, 30 there. And that happens in a number of these columns. Okay. That is extremely misleading the way that she created this chart. And here's why. I can't tell you for sure off the top of my head how many human beings populate the earth right now. I know it's over 8 billion, but I can't tell you exactly how many. But one thing I can guarantee in all those people, they all share 99.9% of the same DNA profile. It's the 0.1% that makes forensic DNA work. So where you see all these numbers repeated, it doesn't necessarily mean anything. It looks pretty. It looks like, oh, wait a minute, we took that sample off of his uniform and look at all these numbers that are the same. Oh my goodness. Yeah, 99.9% of DNA is shared by every human being on this planet.
But the way it's presented here, it looks like it
The
makes
way
it look more nefarious for
the
Daniel.
way this chart is put together, along with her verbal testimony, it makes it look like the DNA was positive for all this stuff when it wasn't. Okay. This explains the statistical threshold in a graph. Okay. This is a reference sample. This lower one where it says reference profile. That's if you took a DNA sample, an absolute clean, unmixed DNA sample, and got a profile for it. Okay, I can tell you right now that the national standard for finding DNA material and being positive is right there. See this evidence profile? None of them get anywhere near that.
When you say, wait, what? So when you say evidence profile, you're talking about in Daniel's case specifically?
I'm talking about in any case where DNA evidence is used.
Oh, okay, gotcha. Okay. Oh, so
The national standard for matching is here for a mixed
Gotcha.
sample. Okay.
okay.
If you look at the sample evidence profile at the top, none of those peaks come anywhere near this line right here.
Okay.
They're all below the national standard.
So
That's what she did. What she did is she went, oh, okay, well, the national standard's here, but I don't think I'm going to use the national standard. I think what I'm going to use is this standard right here.
wow. Okay.
Yeah, there's some peaks that go above the standard line that she used, but how many of them?
Right. And in what markers, or I don't know what the right words
Exactly.
are to
First, you
okay.
got to see if there's a result above your standard line, your standard threshold. Then you have to look at what those genetic markers are.
Okay. Sharon Sunshine wants to know, but how can she do that? She just did it.
Because these forensic, like I was saying earlier, these forensic labs are not forced to follow the national standard.
Yeah, that's just wrong. That my mind boggles because I think, well, how can we change that? How can we force every lab to use the national standard? But
It's going to take literally an act of Congress.
Act of Congress, literally, yeah.
That's how they
Yeah.
got the 55-mile-an-hour national speed limit in back in the 70s. Was it took an act of Congress. Now, that law has since been repealed, which is why you find different speed limits in all these different states on the interstate. But that's what it took to get that 55-mile-an-hour speed limit passed. To force these labs to follow the national standards is literally going to take an act of Congress.
Well, then let's go to Congress, you guys. Let's go. I mean, if I knew how to do something like that, I absolutely would. If I knew how to even start some kind of petition or something to because it's not just Daniel's case. I mean, of course, that's the case I focus on because it's so egregious, especially with the, overzealous amount of time. But anyway, it's just I can't. It's hard to accept and tolerate. It's very difficult, and Tony Hay says, in other words, you're saying she has no concrete evidence and is manipulating the jury.
Absolutely, she is. She did it verbally, and she did it by the way she created that chart.
Right. And then we had the DA. Of course, I want to let you keep going, but you know, those that are familiar with this case know that the DA, in his closing rebuttal argument, literally lied to the jury about the DNA. And that's not well, and I don't remember if it gets brought up in this
Oh, yes,
in
it
this
does.
brief. Okay, all
It
right,
does.
I'll let you go. I'll let you go then. Sorry. Yes, and they're picking and choosing. And Sharon, Michelle Malkin literally says that when she's doing an interview. I can't remember which one it is now, and I didn't get all the description, all the stuff. I'll put the stuff in the description box before after we're done here. But anyway, Michelle Malkin literally says that. How can they pick and choose? Cherry pick basically what they want it to be. So very good observation. Okay, go ahead, Rick.
Okay. Here's where I call it the collaboration. The panel that wrote this doesn't outright come out and say they collaborated, but here's where I think the collaboration between the lab and the detectives that were out to get somebody started. The forensic analyst informed female detective early on with respect to June 18th, 14, the beginning of the investigation, that Q2 contained the complete DNA profile of an unknown female major contributor. Well, first of all, no, it did not contain a complete DNA profile. For it to be a complete DNA profile would mean that sample 17Q2 had all 23 chromosomes intact in the sample. And it didn't. So no, it did not contain the complete DNA profile. She lied. This discovery led to a police investigation to search for the unidentified female by focusing only on possible consensual or criminal sexual transfer of DNA. This is where they created the list or the packets, depending on who describes it. They went back and looked at all the females that fit a certain profile, criminal profile, interaction profile, that Daniel had been in contact with to try to find who belonged to this DNA. This is where it started. They point that out. Despite the problems with the accusations, police used her background while developing a victim profile to search for the mystery female. Although Miss C2 had no warrants or drug convictions, an OCPD lieutenant created a victim profile by assuming that Mr. Holtzclaw had targeted African American females with criminal histories and arrest warrants. The forensic analyst is the one that started that entire thing by coming and saying, oh, hey, I've got one complete female DNA profile. She lied about the profile, and they ran with it.
And also, just to add, I mean, I don't know that we have any records. Well, maybe they're out there, I'm sure, but I don't know that I have them. But this person, this female, was not the only female that Daniel was in contact with that day. There was at least one other female that was in. It was a group of 3 that he stopped initially that day, and it was
Yep.
one male and 2 females that he had, searched and handcuffed, and also had skin to skin contact with, and did a pat down on. And there was 2 females that day. So, but we're only choosing one of the females. That
Mm-hmm. Well, the forensic analyst is saying that she only got the complete profile for one female.
okay, like Sharon says, picking and choosing.
Mm-hmm.
Okay.
The detectives then contacted these women, telling them that the police had received a tip that the women were possibly sexually assaulted by an Oklahoma City police officer. Guess who the tip came from? The forensic analyst.
Yeah. Oh,
It
yeah.
wasn't a potential victim or a victim. It was the forensic analyst. It was the forensic analyst's statement that she had one complete DNA profile that didn't match the person they knew about at the time. That was the tip to go searching for another victim.
Kind of to Cherie, that is not something my mind never worked that way. Did you ever, excuse me, excuse me, did you ever, Cherie, did you ever like think about that or contemplate whenever, especially Kim Davis kept saying, I've received a tip. Did you ever connect that tip was coming from Elaine Taylor? I never did. I just figured she was just lying. Well, I mean, it is lying, but a different kind of lie.
Well, what Kim Davis did is she took the information that Elaine Taylor gave her and manipulated the way that she related how she got the information to these women to make it sound like a person came to them and said, "Hey,
Right.
I think that woman got sexually assaulted by a police officer."
To me, she kind of combined the the DNA allegedly found and her list, and put the 2 together, and that was the tip. I don't know.
Yeah.
That's what you mean, but
That, or also implying that another victim has already come forward and given us a tip that
Yep.
you might have been a victim of this as well. Okay. Okay.
The male detective admitted he could have told multiple interviewees that the police had a lot of victims, a long list of women. In other words, you're not the only one. What was it Kim Davis said that one time to that one supposed victim? We got the guy. We know who he is.
I know what officer did this to you.
yeah.
Told
Before
that to
it was at the beginning of the interview, or was it on the phone call
I
beforehand?
think it was on the phone call.
Okay.
That's how she
No.
got her to do
Oh.
an interview.
Yeah, but she told, and it was Sherry Ellis. She told
Yeah.
Sherry Ellis in her face-to-face interview, I know what officer did this to you.
Mhm.
And I think that was after Sherry Ellis had described him as a short black man. And then, you know, Davis couldn't, she couldn't get around that description because, she's already convicting or judging or, saying that it was Daniel that did this, but she can't get around Sherry Ellis's description. And I think it was after that she said, I know what officer did this to you. If I'm not mistaken, it's been a minute since I've listened to that interview, but anyway, I'm sorry. Go ahead, Rick.
No, you're okay. So they contacted 40 African American women. 33 of them said nothing had happened. ultimately got 9 women to go, oh yeah, that happened to me. Look at their next statement. When none of these women matched the unidentified female DNA profile, detectives then started looking at every female he ran before he was put on administrative leave and working backwards. This process led to a 10th complaint whose DNA matched the major contributor in samples. Notice the wording of that. Not the sole contributor, not the exclusive contributor, the major contributor. In other words, the DNA sample was not a complete profile.
Uh-huh.
Oh, I forgot to highlight that. Highlight that now so I can save it, and then it's there. Whoops. Come back here. Yes, that's what I want. The DNA evidence from the fly of Daniel's uniform pants was highly prejudicial but had little probative value. This is important because it was consistent with non-intimate DNA transfer, and crucial accepted forensic science steps were omitted during evidence collection and testing.
Well, you see, that's another standard. I'm being facetious here. In Oklahoma County, they don't have transfer DNA. They don't have touch DNA. It doesn't happen.
Yep. According to Kim Davis, Rocky Gregory, and
Okay. The forensic evidence consisting of DNA matching the profile of Miss C1 along with DNA from unknown individuals was prejudicial because the location on the fly of Mr. Holtzclaw's uniform pants appeared incriminating. However, it had little probative value because the complainant's DNA profile was not found without any visible, our DNA profile was found without any visible stains or deposits, without any body fluid testing, and with low quantities of DNA and mixtures from unknown people, such that it can be explained by non-intimate transfer of skin cell DNA from Miss C1, her clothes, or her possessions to Mr. Holtzclaw's hands when he searched her purse and pet searched her, and then from his hands to the fly of his uniform pants during a restroom break.
I'm really sorry, but I have to just throw in my comments as much as it hurts my head. Kim Davis and Rocky Gregory said to Michelle Malkin in their interview that wouldn't be possible.
Oh, it's absolutely possible.
Yeah, well, they are the forensic scientists in Oklahoma County City, so just kidding.
This is a quote from DNA Transfer, A Never-Ending Story, a study. I suggest everybody go and read that study. It's very informative. The low probative value of the DNA in Mr. Holtzclaw's case was reduced further because the state omitted important steps during collection and testing of the uniform pants. The state did not conduct tests to distinguish between transfer of DNA with body fluid or without. State also did not consider that DNA may have transferred innocently either before or after the alleged crime, including by contamination. Remember when we said he put his pants and his belt in the same bag?
Yes.
What if her DNA
Yes.
was on the belt?
Right.
And when he stuffed it in the bag with the pants, that DNA transferred to the pants.
Right.
We'll never know because they did put it all in the same bag. They also didn't individually wrap them.
Rick, can you say again which article that is, or which study that was that you suggest, and I'll find it and put it in the chat.
Yeah,
Thanks.
it's the Janine Helmus, Thomas Banachowski.
Okay.
It's called DNA Transfer, Never Ending. So I'll leave this up here on the screen for a second so that you can get it.
Okay, I've got it here. I've got it in the brief that I'm looking at.
Okay. All the reasons I've talked about a couple of times now. As a result, investigators did not take crucial steps to prevent DNA contamination of the fly of the uniform pants due to DNA indirect transfer. It had a valid non-sexual explanation. A reasonable explanation for the DNA matching Miss Cieslund's profile on the fly of the uniform pants is that it resulted from indirect transfer of her non-intimate skin cell DNA, which refers to DNA deposits that are invisible to the naked eye, are left behind on surfaces due to non-sexual epithelial skin cells, or cell-free DNA and sweat, and are usually deposited in smaller amounts than DNA found in blood stains and other bodily fluids. Remember how part of the testimony was, well, there wasn't enough material to be able to make a match. Oh, gee, does that sound familiar? Research proves that non-intimate DNA indirect transfer occurs even to incriminating locations. Okay. Now we're getting into whether it's direct transfer or secondary transfer. This relates to what is called, how we classify somebody as what we call a shedder. We classify people as shedders by 3 different classifications: good, poor, and intermediate. And intermediate takes up all the distance between good and poor. Basically, what your shedder profile, what it means is how much DNA you just naturally slough off of your body when you touch something, or you brush up against something, or you pick something up, or if you're a poor shedder, you're not going to leave a lot of DNA on stuff. If you're a good shedder, you're going to leave a ton of DNA all over the place. And that's what they're talking about in this line on that I have in yellow. Secondary transfer, and tertiary or higher level transfer. If you're good, you're going to have a higher level of transfer, such that no physical contact between the original depositor and the final surface on which the DNA is located. There's absolutely no reason to believe that it could not have been innocent transfer. This should have been pointed out. Numerous studies in existence before Mr. Holtzclaw's trial began on November 2, 2015, proved that non-intimate DNA direct transfer occurs, yet none of these specific studies were brought to the jury's attention. They knew for years that indirect transfer happens. Of course, the prosecution is not going to bring it up. Why didn't his defense attorney?
That's like almost like a rhetorical question to me because, I think there
Yeah.
were lots of mistakes.
Yeah. What's the date on this? This was July of 2017. This was filed, right? Yeah.
Yes.
The first study demonstrating non-intimate skin cell DNA primary and secondary transfer was conducted 20 years before they wrote the brief. They'd known for 2 decades it was possible. Showed that DNA can transfer from a person's hand to a tube and then from that tube to another person's hand. Study by Jones and Scott, published 5 years before the trial, revealed that a woman's DNA can transfer indirectly from her face and hands to a man's hands, and then after the man unzipped his pants, from his hands to his cotton underwear and even his penis during simulated urination, such that the female DNA was found on 33% of the underwear sampled. 50% exhibited 15 plus alleles, and also on 67% of the penile swabs, 1 to 5 alleles.
Rick, can I ask you a question before you go on regarding penile swabs? So, during the interrogation, the only individual that they're talking about is Janie Liggins, who he had stopped earlier in the morning, and so she had only, well, actually, now that I think about it, it should have still been relevant. But anyway, she accused Daniel of oral sodomy, making him suck his penis. So even though he had been home that night after he allegedly orally sodomized Janie Liggins, he'd gone home and showered, let's say, which is what I think he probably said, which is what I think he said, I believe. And gone home after this alleged incident and showered and then went to bed, got up the next day, got dressed, and he did wear the same uniform pants from the night before. Would there have been any point in doing a penile swab ordering a penile swab to take place that day, same day could that have been something they should have, or
they absolutely should have done it. They also should have collected his underwear.
Right. Yeah. Well, and he says in the interrogation that his underwear were in the washer or in the wash. I can never remember if it said wash or washer, but at any rate, I don't believe he said they'd been washed. I mean, he hadn't been home long enough, I don't suspect, to actually wash those underwear from that night.
They should have gone and collected them. They should have gotten a warrant and gone and collected them.
That's what I think Sheree and I have always agreed that should have been done as well, but it wasn't done. So no penile swab that could have been useful, and no collection of his underwear or any other things that they may have been able to use for evidence via a warrant in his home.
Yeah. So, well, there are studies that show that even after laundering clothing, there's still some DNA that can be left. The other thing is, Oh, we didn't do a penile swab because he said he took a shower. Okay. How do you know he's telling the truth about taking a shower?
Exactly.
Now, I have no doubt that he was telling the truth when he said, I went home, took a shower, went to bed. But as an investigator, you don't just take a suspect's word for it.
Right. You can't just assume they're telling the truth. And listen, really quick, and I'll shut up again. But as much as they called him a psychopath, and I can't even remember all the horrible descriptors they used, but a psychopath, and accused him of, well, they didn't really come right out and accuse him of using steroids, but they implied it in the interrogation, or at least Rocky did. And all of these horrible names that they referred to him, but they're going to just believe that he took a shower the night before and washed his underwear. I mean, that doesn't make sense to me. Okay, I'm being quiet now.
You're all right. I wanted to make sure to underline this as we were doing it. This was an actual test that got done. Researchers found that skin cell DNA transferred tertiarily from the neck of one individual to a cotton cloth that had been rubbed for 5 seconds on the donor's neck, then from the first cloth to the hands of a second person, the carrier, and finally from the carrier's hands to a second piece of cotton cloth. DNA testing of the second cloth was able to provide the complete DNA profile of the original donor in 22% of the samples. Research by Kale, first published in September of 2015. This was just not long before things got all involved, revealed that shaking hands with the second individual and then touching a knife can transfer the second individual's DNA, but not the handler's DNA to the touched object. Other studies have obtained similar results. The full DNA profile of one individual was recovered from an item they had not touched, while the profile of the person having contact with that item was not observed. Well, they did find Daniel's DNA on his uniform pants in the areas they tested, but there is the forensic analyst's threshold again, saying that there wasn't enough of it to match. In fact, I believe the way she testified was no male DNA was found.
So it was either no male no, because she couldn't, well, I don't think she said that, because she said one unknown male, or at least one unknown male, if I'm not mistaken. But it wasn't Daniel.
There are areas that she said one unknown male. There are areas where she said he was excluded even though he wasn't.
Or shouldn't have been.
And then there are places where she said no, there wasn't any.
Right. Okay. So just I just want to suggest to folks who are listening to this for the very first time, this part of Daniel's case, not the link that I put in the chat just now, but I'll put a different link in from the one that we did 2 weeks ago, and that talks about, I've lost my train of thought, but because it's exploding out, my brain's exploding out of my ears, but I'll put it in the chat. But I suggest that you go back and watch, after we're done here, go back and watch these last two that we did. The last one was about the secret hearings. So as those secret hearings relate to what I think, what was speculated, based on the fact that Elaine Taylor's supervisor, Campbell Ruddick, was in these secret hearings. I think if you go watch the one I just put in the chat, and then I'll put the next one I'll put in the chat, watch those in order of where I put them in the chat, and then think back to this or rewatch this again, and you can kind of get a picture of how it all connects. Okay, I'm sorry. Go ahead.
No, you're all right. Talking about vaginal stains and how they appear, they give various physical descriptions of them. This is the important part of it, though. However, recent research has revealed that after just 2 minutes of consensual sexual intercourse without ejaculation, stains are visible on men's underwear that they donned after intercourse, causing their genitals to come in contact with the cloth of the underwear. The underwear that they never got the warrant for and went and collected. Based on these research results, there would be an expectation of visible staining on the fly of Mr. Holtzclaw's uniform pants if he had, as alleged, raped Ms. C1 for about 10 minutes through the unzipped fly of his unbuckled pants, confiscated less than 24 hours later. The complex DNA mixtures were typical of indirect transfer. Although Mr. Holtzclaw's trial defense attorney did not reveal this during the trial, the defense argument is additionally supported by the observation that the samples were mixtures of DNA from several individuals. There was more than just her DNA. Which is typical of the complex DNA mixtures frequently found due to non-intimate DNA indirect transfer. Biological substances that have been transferred multiple times, if detectable, will often appear as components of complex DNA profiles for more than one individual because DNA may be present on the vectors on which it transferred or on the substrate from which the DNA is collected. In other words, you get all this DNA mixed together from various sources, and then it gets on all that DNA mixture gets on one person's hand and they touch something. You're going to get that complex mix of DNA, even though only that one individual touched it. If I walk around and I shake 11 sweaty hands and then take a cotton handkerchief out of my pocket and get the moisture from taking the sweaty hands off of my hand, it's absolutely possible that there's a mixture of all those 11 people's DNA on that handkerchief. Mine may also be on there. Mine may not be on there. It's not guaranteed that mine will be on there. It's not guaranteed that all 11 people's will be on there, but there's going to be a mixture of some kind. But I'm the only one that ever actually touched the handkerchief. We are concerned the DNA evidence's probative value was reduced further by the omission of critical forensic science steps during evidence collection and testing. The state did not follow the crucial forensic science steps for developing, investigating, and testing alternate hypotheses during evidence collection and analysis to distinguish among 3 hypotheses that could explain the DNA evidence. Okay. Body fluid, non-intimate skin cell transfer via his hands. When a DNA match is found, the conditions of transfer must be investigated. Investigators must vigorously investigate evidence possibly resulting from secondary transfer, including due to contamination by investigators. Remember the bare hand opening the bag up and flopping around in there to make sure it was all poofed out? Yeah. The investigator must take into account the relationship between the victim and the suspect and any possibility of innocent transfer of DNA that may have occurred before the alleged crime. Daniel was a police officer. He admitted he stopped her. We've got the records of him running her name. These women's names. We know that he interacted with them. He never denied that he interacted with them. He denied the allegations that they cooked up in collusion with the detectives, but he never denied that he interacted with them. Is there an innocent explanation for secondary transfer? Yeah, he's a police officer. He stopped the victim. He's the supposed victim. He searched her purse. He patted her down for possible weapons. He handcuffed her. That means he had to touch her wrists and her hands. There's tons of reasons for why her DNA could have been on him. What just blew up?
Sorry. It was probably me. My coffee maker. From what you may have said this already, but from what I understand, even touching something that the lady touched without actually touching her could have transferred it. Is that your understanding too?
Oh, absolutely, that could happen. That goes back to how good of a shedder are they. If they're a good shedder, every time she put her hand in her purse, she could be leaving DNA in there. He searches their purse and touches the items in there. He never laid a hand on her, but her DNA in her purse may have transferred to his hand. It's absolutely possible. It's absolutely possible.
Before you go on, I think Cherie has to leave, so I just wanted to let everybody know she's going to take off. She's got some family dinner plans, so thank you for being here, Cherie. Thank you for all of your contribution, and enjoy your family dinner time.
Thank you. See everybody later.
Keep safe, kiddo. Okay. Investigators do not appear have to consider the possibility of non-intimate DNA indirect transfer, as is shown by evidence handling methods that created risks of DNA contamination. Here you go. Rhonda, here's what you were talking about. Detectives only collected the uniform, pants, and belt, but not underwear and penile swabs that could have offered more data. The detectives made the decision not to go retrieve the underwear. They didn't even take the underwear he was wearing at the time of the interrogation.
You're not even halfway, well, almost halfway through this by now, but it just what little bit you've shared so far is astounding to me. How, first of all, all of this made it through the first trial, but well, there wouldn't have even been a trial. I mean, at least
There
in my
shouldn't have been
opinion,
a trial.
yeah, there shouldn't have even been a trial. But I, this should at least, be allowed for like an evidentiary hearing or a second or a new trial or something.
You
Just
would
with what
think
little
so.
bit you've shared,
Yeah, you would
because
think
we
so.
haven't even gotten through it all yet, and just that amount is just oh God, it upsets me. Okay, go ahead, Rick.
Not collecting that swab in either pair of underwear was incorrect because the recommended procedure for sexual assault investigations is that any item that potentially corroborates or refutes an allegation, quote, must be seized and recovered. There again, not bothering to follow the guidelines, not bothering to follow the standards. The female detective gave 2 invalid, I like the use of that word, invalid, I call them idiotic, reasons for not obtaining the underwear that Mr. Holtzclaw wore during the alleged sexual assault. Mr. Holtzclaw said the underwear was in the washer, and she believed, possibly incorrectly, that this meant the underwear had been washed. Second, she stated that the effect of a washing machine on evidence is it, quote, washes it away. No, actually, there's tons of studies that say that's not true. Similarly,
I'm sorry. Did you say that the crime lab analyst testified to that?
oh,
Is that what you just read?
that's the no. I'm talking about Kim Davis.
Oh,
Kim
Davis.
Davis stated that the effect of
Yeah.
a washing machine on evidence is it washes it away. But the next sentence in that paragraph, similarly, the forensic analyst testified that DNA evidence on clothing is washed away in a washing machine so that it is gone. Contrary to their beliefs, even clothing that was worn at the time of an alleged assault and subsequently washed should be confiscated because machine washed underwear can yield DNA evidence and provide complete DNA profiles, including sperm, vaginal fluid, or blood deposited prior to washing. This goes back to her being a poor student and never doing continuing education. It's absolutely possible to find DNA even after you run it through a washing machine.
I think we talked about that too, washing, things that are alleged to have come in contact with, semen or whatever, blood, semen, saliva, when we did Rosetta Great's case, because they talked about, I can't remember if it was Elaine Taylor testifying, but they talked about they didn't bother collecting or testing the comforter that Rosetta Great claimed they were both in contact with, her and Daniel Holtzclaw. They didn't bother testing it because she said she'd already washed it anyway.
Mm-hmm.
And I remember thinking at the time, but can't they still, I mean, what's the harm in trying? You know what I mean? But anyway.
Absolutely. They should have collected it and tested it. I wouldn't want to try to unwrap the DNA puzzle that was on that thing, considering what her occupation was, but
Yeah, true, true.
additionally, the OCPD detectives erred by choosing not to initiate a thorough forensic exam of Mr. Holtzclaw, not even a penile swab. Investigators should complete a forensic exam of the suspect's body, including a physical exam with penile swabs when the suspect is male, and should use, ready for it, an alternate light source to find possible body fluid stains on the suspect's body. When less than 24 hours has elapsed since an alleged sexual assault, regardless of whether the suspect has bathed or changed clothes.
And listen, I read this amicus brief when I first was able to get a hold of it. Almost 5 years ago now. So, and so it's been a long time since I've read it. So some of these details, as you read them or point them out, come back to me. But thinking back on it now, I remember thinking that was just common sense to me. That was what my common sense said would be logical. A lot of these things. So,
It's more than logical. Look at the quote from Savino and Turvey down at the bottom of this paragraph. In cases involving suspected sexual assault, victim and suspect examinations are part of standard forensic protocol.
Yeah.
This is what, going through this amicus brief, like the fourth or fifth protocol we found they didn't follow?
yeah. Remarkable.
This thing, their entire investigation and handling of the evidence is riddled with violations of protocol and standards.
Which should, using my common sense and what little bit of knowledge I have, which should be cause already, just with the ones you've pointed out, should be cause to throw out the verdict. I don't know what the proper terms would be to use, but
no, the verdict should be overturned and at a minimum a new trial ordered. Yeah, absolutely.
Overturned was what I was trying to. Yeah. Okay. Go ahead.
The state's forensic analyst completed no tests for body fluids, not even use of an alternate light source. For anybody that came in late, she used just a bright white light. Doesn't say whether she used a flashlight or an overhead light or a desk light or what, but if she had bothered to use a light source looking for those fluids, considering it was oral, it should have been this one right here is the pattern that should have shown up.
And if she had, here's another random thought. If she had used an alternate light source and detected some stain or visually saw some stain and did what is it called? Overhead light source?
Alternate light source.
Alternate. I know these terms, but I'm not thinking at full capacity, so I apologize. But if she had done that, perhaps she would have found that really the only thing that was on the outside of his pants by his zipper might have been, some sort of protein drink Daniel might have drank, or a juice or chocolate milk or milk. You know what I mean? It could have,
chocolate milk would have left a visible stain.
Right. Yeah. That's why I'm seeing, maybe a juice, maybe a juice or, something like that. But, and then we wouldn't be here talking if that had been the case. That's just me playing, devil's advocate, I guess. So anyway, go ahead.
I'm going to keep this slide up here for a minute because one of the accusations was that he actually penetrated the woman. And they made a big deal of asking her, did he come? Did he ejaculate? For those that are not into biology, let me explain something to you. There are two emissions that happen to a man with a man that is sexually excited. There's what's called pre-cum, which is the clear fluid that you see. Guess what that clear fluid is? Whoops.
Doesn't it have? Yeah, sorry, go ahead.
Well, I'm going to draw something here, and then I'll... Right there. That's what that clear fluid is.
Semen. Yeah, that's
It's
what
semen.
yeah.
What
I
makes
almost said that.
What makes it milky white when they ejaculate is the sperm.
The
in
sperm,
it.
right. That's what I thought.
The pre-cum, which acts as a lubricant, is just pure semen. So even if he didn't ejaculate, if he had penetrative sex, there should have been some of that on there. Never tested for it. Never
Right.
looked for it. After all, they claim he got so excited by these women. The DNA profile matching Miss C1 lacked probative value because, again, this is a breach of protocol and standards. The OCPD forensic analysts, did not test the uniform pants and belt for the possible presence of body fluids, choosing instead to view the uniform pants only with a bright light and a magnifying glass. Forensic scientists, the forensic analysts omitted the use of an alternate light source to identify possible latent stains that fluoresce, including saliva, semen, and vaginal fluid, and she performed no presumptive tests for saliva.
Wait, okay, I'm confused because I didn't think they could test for vaginal fluid.
It fluoresces the same as semen.
Oh, gotcha.
Under an
Fluorescing.
alternate light
Gotcha.
source. Yeah.
Gotcha. Okay. Yeah.
Yeah. She never put an alternate light source on it. Never. The forensic and I keep trying to say scientist, the forensic analyst's reason for not testing the pants for saliva after the Ms. C2's allegations for oral sodomy reveals that she did not consider the possibility of non-intimate DNA indirect transfer. Quote, at the time I felt an amylase test would not have aided anybody in the investigation of this particular case. Let me translate that quote for you. I didn't do it because if it came back negative, we couldn't get him.
That's what I was trying to. Yes, exactly. If it came back negative, my son-in-law and his partner and everybody else in OCPD and the DA's office wouldn't have had a case.
That, by the way, is a blatant lie. Would not have aided anybody in the investigation of this particular case. How about the accused? If it had come back negative, would have it aided him? He was involved in the investigation. He was
Sure.
the subject of the investigation.
And that would have been, if I'm not mistaken, exculpatory evidence.
Exactly. That exculpatory evidence with a negative result certainly would have aided the suspect, the subject of the investigation. But no, I didn't do it because it would not have aided anybody.
And I have the same reaction or comment as it relates to the secret ex parte hearings, because the judge determined that even though it involved, I don't know, I'm paraphrasing words here or making them up or something, but at any rate, something to the effect, even though the crime lab supervisor was involved in the hearing, it was all for personnel matters, and nothing that we discussed would have benefited or affected, whatever his words were, the defendant anyway. That's twice at least now that kind of mentality has come into Daniel's case.
Mm-hmm. Oh, it's a lot more than twice. A lot more than twice. You look at the entirety of Daniel's case from beginning to present day, it's multiple times.
Yeah, definitely. Yes.
The forensic analyst's decision to do no body fluid testing was incorrect because body fluid traces are one of the most important types of evidence to forensic investigators, especially when non-intimate DNA transfer is a reasonable possibility. He's a cop. He searches purses. He pats people down for weapons. There's a reasonable possibility of non-intimate transfer. Why didn't she test for fluid? Identifying a fluid can impact the trial verdict, and therefore the first step of DNA profiling should be to examine the exhibits to detect the presence of body fluids and identify them by using light sources and chemical tests. Never did it. It is agreed. This goes to me saying Daniel never denied that he had contact with her. It is agreed that Mr. Holtzclaw and Miss C1 had non-sexual contact. This is why the mere presence of a DNA profile cannot be attributed to sexual activity without supporting evidence of body fluid identification. Finding DNA on a suspect's clothing has an entirely different probative value when DNA originates from the epithelium versus body fluids. Epithelium is a fancy word for skin, basically. But what did she testify to at the trial? Oh, it definitely came from vaginal fluid. How do you know? You never tested. You never checked. You lied. You committed perjury. You said it absolutely came from it. You don't know that. You never looked. The state did not investigate the source of unknown female and male DNA that could support the hypothesis of non-intimate DNA indirect transfer. Discovering unexplained and unexpected DNA from a mixture of individuals, including at least one unidentified male. So yes, there is somewhere in the paperwork that says unidentified male DNA was found. Required consideration of who may have contributed to the DNA samples in the chain of events that led to the DNA being present, so that the likelihood of alternate scenarios could be assessed. Yet both the state investigators and Mr. Holtzclaw's trial defense attorney did not do this. Why?
It's they couldn't have made fabricated a serial rapist. That was
Exactly.
Daniel Holtzclaw.
Exactly. It would have hurt their case. The state omitted investigating whether Miss C1's male and female friends with whom she was stopped could have contributed alleles to the DNA samples which would support the scenario that non-intimate DNA from all three individuals transferred to Mr. Holtzclaw's hands when he questioned them. That's a fancy way of saying they never went and took a DNA sample from the two people that were stopped with her.
Right. Yep.
Didn't even go look, see if maybe they went back months looking for somebody who fit the DNA profile of one, according to the forensic analyst, unknown female DNA profile. They knew the names of the two people that were stopped with this woman. They never bothered to get a hold of them and get a DNA sample.
Well, and the thing is that they actually questioned, I can't remember, I think Chocolate was the name, her street name, that was with, I'm just going to say her name because it's not a secret anymore, but with Adara, who was the 17-year-old. She was, the first interaction with them that day was the female who went by the street name Chocolate and the male who went by the street name Face. And so, but they did interview Chocolate. Kim Davis interviewed her, but they didn't, like you said, bother to get a swab of her DNA. I don't believe they did. I don't believe they took a swab of her DNA.
Oh, exactly, Jennifer. I wish I had video recorded the first time I read this brief.
Jennifer, thank you so much for the dono. Thank you for the dono. I truly appreciate your support and your donations. Thank you so much. Yeah. Yeah.
I was almost a stark raving lunatic the first time I read this brief.
Right. Especially knowing, I'm assuming that you already knew everything that had taken place beforehand, with the exception of transcripts that you didn't have. But so, yeah. And each time I like, and exactly like what Jennifer said, it was the same with me and Cherie. Every new thing that we tried to research, we found more, just our own, well, in my case, layperson common sense, just things that were common sense to me as a layperson. And so and it's still 5 years later now, it still infuriates me even more so than it did when I first started.
Here's another standard that they violated. DNA elimination samples should be obtained from individuals who may have contributed to DNA mixtures. So the two people that she was stopped with, Kim Davis and, God, I keep saying the male detective. For the life of me, I can't remember his name. Was that Rocky? Or was Rocky the
Gregory.
lieutenant? It was okay. Rocky was the detective. I always get Rocky and the lieutenant's names confused in my head.
Lieutenant Musney and Detective Gregory.
Yeah.
They're both assholes, so.
So both individuals that were stopped with her, an elimination sample should have been taken from Rocky Gregory and Kim Davis. Why? Because they handed him ink pens to write with. Their DNA could be on those pens, and then without doing anything that could have removed their DNA from his hands, he took his pants and his belt off and stuck them in the bag that Rocky Gregory had flopped his bare hand around in. Never took elimination samples. How do we know the unknown male DNA wasn't Rocky Gregory?
Yeah, we don't know. And just
Is it
so
him? I don't know, but that's the
we
whole
don't know.
point.
Eliminate him. And just so people know, Rocky Gregory, right after Daniel's trial and conviction, Rocky Gregory was promoted to homicide. Let that sink in and terrify you just a little bit.
No kidding. We are concerned that the state's handling of the evidence could cause contamination that may have transferred DNA from Miss C1 and others to the fly of the uniform pants. What they're talking about is the process I described of you wrap each item individually in clean butcher block paper and then put it in the paper bag. They didn't do that. They stuffed it all in there together. Lastly, the DNA from the fly of the uniform pants had little probative value because the state did not undertake crucial and accepted forensic science steps to prevent the possibility of DNA contamination by investigators during evidence collection, storage, or examination. Now, I want you to pay very special attention to that word examination. We already knew from watching him give them his uniform pants and belt in the interview video that Davis and Gregory didn't follow standards. What did they see in all the paperwork they got to look at to write this brief that happened with the forensic analyst during the examination to prevent the possibility of DNA contamination? Because the forensic analyst is the one that examined it. So what did they see that makes them believe that she did something that could cause the possibility of contamination? I don't know. I would love that question answered. That's a very important point to me.
Yeah. Yeah, it is. It's very, and it's an answer we'll never get, but absolutely.
We've already touched on this. Staff elimination DNA samples from the detectives and other investigators do not appear to have been compared with the DNA samples to be quite honest with you, I don't even know that Oklahoma City PD does baseline elimination samples when somebody goes on the department.
I'm not certain of this, but I feel like it was a question that was asked, and perhaps during trial, maybe that, and it was testified to. I'll have to find it to be sure, but I feel like I remember something in trial that came up about elimination for the detectives and whatnot.
Yeah,
having
well, we know for
onboarding.
certain they didn't do it.
Yeah, right. Yeah.
But, I could see maybe not having a baseline DNA sample for every street officer. But
Right.
once you become a detective where you're going to be working in crime scenes investigating, there absolutely should be a baseline sample taken for elimination.
I agree.
They list 5 different possible routes that DNA may have contaminated the fly of Daniel's pants. The trial defense attorney mentioned none of them. Didn't raise a single one. Alleles from unidentified individuals, including at least one male, could have arisen from the female and male sex crime detectives during their interrogation of Mr. Holtzclaw due to secondary transfer via pens they handed him, after which he rubbed his pants frequently, ultimately touching his Velcro belt and possibly the fly of his uniform pants while unzipping them, as revealed in the interview video. Contamination of the uniform pants and belt may have occurred due to DNA transfer after the male detective violated proper evidence collection procedure by failing to wear DNA-free gloves and instead pushing his bare hand into the evidence bag before Mr. Holtzclaw placed his pants and belt in the bag. There is another standard that was broken. The detectives violated standard procedures for evidence collection by packaging 2 items, the uniform pants and the belt, in the same evidence bag, creating the potential for cross-contamination of DNA from Miss C1 as well as other individuals from the belt to the fly of the uniform pants during transportation and storage. These people are real winners, let me tell you. And oh, by the way, the source for these standards, look right there. This isn't just for the US or the state of Oklahoma. The International Police Agency, Interpol, DNA Monitoring
Interpol.
Expert Group. This is a world standard.
Well, hell, they don't follow the national standards. They're sure as hell not going to follow any world Interpol standards. But anyway, yeah, just.
Number 4, DNA from Miss C1 and other individuals may have been present on less incriminating locations of the pants, may have transferred to the fly within the evidence bag, or vice versa, since research demonstrates significant quantities of DNA often transfer from one area to another on the same exhibit or other exhibits inside a single bag. Let's go back to the beginning of the stream, or near the beginning of the stream, to the point that KB made. Daniel's evident DNA should have been all over those pants, all kinds of people. He's a cop. He interacted with all kinds of different people, including fellow officers. There should have been DNA from all kinds of individuals all over those pants, except they didn't test any other areas of the pants.
And Galen Gigger was very flippant when he was, made the comment, I believe in his closing rebuttal, that, why test other areas? He's not sitting on the pocket or, sitting on the knee, or, the fly of his pants is nowhere near a pocket or a knee or a cuff. He made just a very flippant comment about that.
Well, except when you wad them up and stuff them in a paper bag.
Right. Yep.
Number 5. I feel like David Letterman in the top 10. The photo taken by the OCPD forensic analyst of the uniform pants shows that they were in contact with what appears to be a red brick surface in one corner of the photo, which raises contamination concerns because brick is not part of a lab bench. Was she opening them up on the wall outside in the smoking area? What was going on?
I believe that was questioned somewhere in the case about the brick wall, the brick top.
It absolutely should have been. There again, the first thing a forensic analyst is supposed to do before they remove evidence from a sealed evidence container is clean the lab bench, and some forensic labs even go so far as to you go and see your family doctor, and the old exam tables you'd sit on, they had that big roll of paper, and after you were seen, the nurse would take it and roll it down and tear the part that you sat on off at the end and throw it away, and there was clean paper on there for the next person. Some forensic labs even have them pull that paper out on the lab table. The state misinterpreted the DNA analysis and made arguments that misrepresented the DNA evidence from the fly of Mr. Holtzclaw's uniform pants. As described in Mr. Holtzclaw's brief, the state and its forensic analyst, I love how they do this all the way through. The state and its forensic analyst. They tie those two into collusion as much as they possibly can, because, in my opinion, they did. Misrepresented the forensic evidence by arguing incorrectly that vaginal fluid was likely to be present in the speculative presence of undetected vaginal fluid was supported by the discovery of DNA matching Miss C1's profile, except they never tested for fluid. They said that's likely where it came from. And it had to come from there because they found her DNA, but they never tested for it. By incorrectly asserting that no male DNA was present in items 17Q3 and Q4, that's where the unknown male was at, and by incorrectly excluding Mr. Holtzclaw as a potential contributor to 4 DNA samples from the fly of his uniform pants. The prosecutor also claimed facts not in evidence, when he claimed in his closing statement that it was a fact that C1's DNA transferred in vaginal fluid. How do you know? You never tested for it.
Well, also, Rick, OC PD Crime Lab didn't have the ability to test for it.
They didn't
You
have
know.
an alternative light source?
Oh, I'm sorry. I thought you were talking about vaginal fluids.
I am. They fluoresce under an alternate light source. They don't have an alternate light source?
No, I
You
guess
can
I
buy
was
one
thinking of
on
something
Amazon for
different.
$25, for the love of God.
I thought you were talking about. I'm thinking about the part where Giger said that it came from from the walls of the vagina. Uh, yeah, never mind.
Oh, you're
I
talking about the epithelials from the wall of the vagina.
Yeah, and yeah, whatever test that requires, or whatever he referenced in his closing argument, that definitively, well, that was the definitive lie that he gave at the end. Um, Oklahoma, they didn't even have the ability to. I mean, I guess there's only very few labs who are able to test for a certain.
If you locate an epithelial cell on something, you know how you determine whether or not it came from a mucous membrane or the skin? It's a very long, involved, very technical process. I'll try to dumb it down for everybody.
No, for me.
You take the swab that you collected the cell on, you wipe it on a glass slide, you put a little bit of staining fluid on it, generally it's purple. You put another glass slide over that to make a sandwich, and you put it in a standard microscope. I'm not joking. That's it.
Yeah. I think I'm thinking of.
You're telling me the Oklahoma City forensics lab doesn't have a microscope?
Now I'm thinking of something different. I shouldn't be really speaking because it's coming out very.
No, I remember him saying that, and unfortunately, you bought his hype.
I didn't. I didn't buy anything
No,
he said.
you just went, well, no, I'm thinking of something different, and I shouldn't be talking. No, that's exactly what he was saying. They had no way of determining whether the cell came from skin or a vaginal wall. Yes, you do. One epithelial comes from a mucous membrane, the other comes from skin. There is
Right.
an absolute, easy, inexpensive way to tell the two apart. You put the cells onto a glass slide, you stain them purple. I can't remember the exact name of the stain, but it's a purple stain. You put another glass slide on top, put it in the microscope, and you look through the lens. The cell walls are shaped different because because they're different type of tissue complexes. It's like looking at a liver cell and a pancreas cell. Are cells from both of them going to have the exact same DNA? Yes, they are, because they belong to the same individual. But the look of the raw, complete cell in the microscope is going to look different. They're two completely different types of organs. At the DNA level, can you tell whether that epithelial came from a vaginal wall or the skin? No, absolutely not. But the morphology of the cell itself under a microscope will tell you which one it came from. It's Gear's just a pathological liar. If you ever sit in a courtroom with him, take everything he presents and his arguments and believe the exact opposite.
Yeah, that's kind of how I that's how I kind of approach him at this point.
Mr. Holtzclaw's trial counsel neither forced the prosecution's DNA analysis errors to be revealed during the cross-examination of the forensic analyst, nor objected to prosecutorial misinterpretations of the forensic evidence. Trial counsel did not make the forensic analyst admit that male DNA was present in all 4 samples from the fly of the uniform pants, and so the implications of this DNA were never addressed. We are concerned that Mr. Holtzclaw's representation was therefore ineffective because criminal justice and DNA experts note that in order to completely represent an individual incriminated by DNA evidence, defense counsel must look beyond the laboratory report to determine whether the lab's conclusions were well supported and whether there is more to the story than the report tells. Effective defense counsel must uncover, understand, and explain ambiguities in the DNA evidence, with one source of ambiguity being mixtures of DNA from several individuals because these mixtures are difficult to interpret. That's a very, very important line right there. Going back to the chart where we talked about all the numbers that match between Daniel's sample and all those other people in the different columns, and remember what I said. Every human being on this planet shares 99.9% of the DNA. It's the 0.1% that makes forensic work. However, the prosecutor's incorrect argument that the DNA matching Miss C1 and the presumed absence of Mr. Holtzclaw's DNA together suggested the likely presence of vaginal fluid is a trial error that was preserved for appellate review because the court sustained the trial defense counsel's objection to the prosecutor's use of hypotheticals. When the prosecutor asked the OCPD analyst if she had an opinion based on her conclusion that Mr. Holtzclaw's DNA was absent, about whether it would be more likely than if the secondary transfer was from Officer Holtzclaw's penis going into C1's 17-year-old vagina. She doesn't even know that it did. She ran no test to show that it did. The state's forensic analyst incorrectly used the presence of DNA matching Miss C1's profile to argue that vaginal fluid was the likely source. Didn't have any evidence of it, mind you, but she argued that it was. The state's forensic analyst made 3 errors while inappropriately using a DNA profile matching Miss C1 to infer that vaginal fluid was likely to be present. Pay attention to the way she testified there. this is very, very important, was likely to be present. She never said it wasn't. She never said it was. But the DNA is there, so if I bothered to use my alternate light source to check, it likely would be. But of course, she never ran the test to know one way or the other. First, the analyst's objective claimed that it was a very good possibility. Okay. There's a very good possibility that Aaron Judge is going to hit a home run in the Yankees game today. But until we test that hypothesis by actually playing the game and a pitcher throwing the ball to him and him hitting it out of the park or not hitting it out of the park, conversely, we're never going to know. But there's a good possibility of it. And then, of course, Giger, the idiot, came in. As the prosecutor phrased it, DNA matching Miss Seawan's profile was much more likely to be transferred if the epithelial cells are contained in a liquid such as vaginal fluid. Okay, so we know the cells were there, or at least he claimed they were there. Was not founded objectively upon the evidence since no visible stains or deposits were observed. No body fluid tests were done, and the forensic analyst herself could not rule out the possibility of non-intimate DNA indirect transfer from the teenager's purse to Mr. Holtzclaw's hands to the fly of his uniform pants. Oh, I found DNA. I think this is how it got there. Okay, how did you determine it got there? Oh, I just think that's the most likely thing. You did nothing to determine if that's the way it got there or not. No, but I think that's the most likely way it happened. The forensic analysts inappropriately used DNA profiles alone to compare the likelihood of DNA transfer via vaginal fluid. What she felt was a, quote, very good possibility.
I'm not talking as much. My head feels like it's exploding, but
That's okay.
so you get a free run here. But is it common to is it common or acceptable to be interjecting so much? I don't know. It almost sounds like opinion, or believe. I believe whatever.
Exactly. And forensic scientists and forensic analysts testifying in court are not supposed to do that.
Yeah, it just seems like a lot of I believe or very good possibilities. I just want a legitimate hypothesis, and a black or a white did or didn't, yin or yang. My brain works like that for the most part.
Well, let me give you an example of what, in my opinion, would have been an acceptable answer. And I'm going to do a back and forth with myself here. Mr. Giger, Ms. Taylor, is it possible that the epithelial cells that is it possible that the DNA that you found was from epithelial cells from the vaginal wall? Now, the ethical and proper forensic analyst would go, is it possible? Yes. It's also possible that they came from somewhere else. That's the way she should have answered that question. That is the only acceptable way she should have answered that question.
Right. Exactly. Okay. That was my thinking.
You know, as opposed to Ms. Taylor, do you think the DNA came from epithelials from the vaginal wall? Oh, it's a very good possibility. No, now you're giving an opinion that you have no evidence to back up. It's like, some of you may or may not know, I worked for quite a while as a professional billiards referee. And one of the most common questions we would get when we got called up to the table to watch a close shot is, if I hit that, will it be a foul? I can't tell you that. I have no idea. Could it be a foul? Yes. Could it also be good? Yes. Going back to Aaron Judge hitting the home run, I have no way of knowing that until you actually take the shot. Could it be a foul? Sure. Could it be good? Absolutely. But until you do it, until you perform the quote unquote test, which is actually taking the shot, I have no way of knowing what the results are going to be. So when I taught the referee certification course, what I taught the referees to say was, I cannot give you an opinion until after you execute the shot.
That's just logical. Just logical.
Which she felt was a very good possibility versus indirect transfer of non-sexual skin cell DNA from the teenager, about which she replied, I cannot disagree with that. When asked by trial defense counsel, she agreed non-intimate DNA transfer, secondary transfer, could have occurred. Notice how she worded that. When the prosecutor asked her, her response was a very good possibility. When the defense asked, is it possible it could have come from this other route? I can't disagree with that. But she gave no opinion on the possibility of it happening. She just said, oh, I can't disagree with that. It is possible. But for it coming from the vaginal wall, a very good possibility. She manipulated her testimony.
Well, yeah, for sure. Just a really quick shout out to Under Your Scars. Thank you so much for always being here, always being willing to comment and share things with us. And I appreciate you so much more than I probably say to you. So I really appreciate your dedication and your support of Daniel and of all of us. Thank you so much, Donna. And yes, they are definitely crooked bastards for sure.
Oh, absolutely they are. The forensic analyst's reference for vaginal fluid transfer was incorrect because a DNA profile alone does not inform about when, where, how, or why DNA transfer occurred. The forensic analyst testified beyond the forensic science professional expertise when she said of the teenager, Miss C1, that a young woman of her age would be very likely to have quite a bit of lubrication that could transfer cells. I can't answer this question because I'm a male, but I'm willing to bet that if I go and round up 100 women that have been sexually assaulted or raped, none of them have created the lubrication that happens when a woman is sexually aroused.
I had the same opinion. The entirety of this part of the testimony during the trial was just so cringe and so I can't think of a better word. Cringe. It was horrible the way she described it in the trial.
I'll hedge my bets a little bit and say probably 97, 98 out of 100 will say no, I wasn't, because you never know in a random group of people when you're going to get that certain sector that finds stuff like that exciting.
Right.
E. Jean Carroll.
I knew what you were going to say. Oh, Rick, you're funny. I like Under Your Scars. That happens. That's what I've heard, but I couldn't really tell you for sure.
Yeah. You want to really get an education of how depraved human beings can be under your scars, go to your next university and just sit in on they call it oh, somebody help me, audit an abnormal psychology class. You will never look at the human species the same way again.
Oh, I can only imagine. I mean, I've read and listened to and heard and seen a lot of depravity over the years, but I can imagine it's much worse than what I do know.
Yeah, it's I'm not even going to go that route because we'll go down a rabbit hole we'll never get back out of. The analyst then did not explain the contradiction between her argument that vaginal fluid should be plentiful and her, I love this, vaginal fluid should be plentiful, and her observation that nothing suspicious was visible on the fly of the uniform pants. Oh, I didn't see anything on it, but she should have been flooding while it was happening because she's young.
It And they give the trial transcript parts there, but it's bad. It's really bad what she said.
The state argued incorrectly that the exclusion of Mr. Holtzclaw as a contributor to the DNA mixture supported a rape scenario. Well, the problem is they couldn't exclude him. That's not what the results said. The results did not exclude him. They never confirmed or excluded. Because according to Ms. Taylor, the genetic markers that would have identified Daniel as contributing his DNA were, and here we go again, below the threshold. Remember our handy dandy little chart? Oops, that's not it. It's in the PDF document. Alleles below stochastic threshold locus not used for statistics. Oh, so she picked a random threshold and went, well, any DNA that matched his was below that threshold I set. So, yeah, he wasn't there. Okay, they were his pants, weren't they?
Which is just so ridiculous. But it also makes me wonder if, in some bizarre, sick way that I believe the prosecution handled the case, if they weren't thinking, let's just make it so her DNA, the accuser's DNA, was so prevalent and so massive that it even drowned out his own DNA on his own clothing. I know that's reaching, but that's what it sounds like to me.
Well, she
Hers
only
was-
tested a very small area.
Right.
I'm
yeah,
willing to
very
bet
small.
if she had tested, halfway down the inside of his pant leg, she'd have gotten all kinds of DNA from him.
Yeah. Or a pocket, or yeah.
Yeah, a pocket where he puts his hand in and out of to get keys and change and hand sanitizer bottles.
Anything, any number of things, that he, but they didn't. And I don't know if everybody knows this, but Rick, I know you do probably, and some who have been here for a while, Liam and Under Your Scars, for sure. But gosh, I can't. I just lost my train of thought. Oh, the those pants were tested 2 different times.
Yeah, year apart.
Yeah. Yes.
Yeah, Q1 and Q2 were taken in 14, and Q3 and Q4 were obtained in 15.
In 15, just months before the start of the trial.
Yep.
Which is where they claim they found the DNA. Well, the all the good stuff, I guess, is how they would describe it. But anyway, yeah, in case anybody didn't know that, I just think that's important to note as well.
The state's forensic. Oh, wait a minute. I skipped a bunch here. The prosecutor presented a flawed argument that vaginal fluid was likely to be present on the fly of the uniform pants, claiming that if Mr. Holtzclaw had transferred Miss C1's non-intimate skin cell DNA via his hands to the fly of his pants, which is commonsensically, he would have had to unzip and touch when urinating. Then you would also expect to find Mr. Holtzclaw's DNA in those locations. No, not necessarily. That goes back to, are you a good shredder, an intermediate shredder, or a poor shredder? This flawed argument was premised on the forensic analyst's unscientific claims that items 17Q3 and Q4 from inside the fly of the uniform pants contained no Y chromosome and thus lacked evidence of male DNA. No DNA from Mr. Holtzclaw was found in any of the 4 samples. An absence of his DNA was very difficult to try and explain. Okay, well, yeah, the forensic analyst testified she found no evidence of male DNA in samples Q3 and Q4. Oh, but look at this. Low levels of male DNA were detected. Contrary to the forensic analyst's testimony that she found no evidence of male epithelial cell DNA in items 17Q3 and 17Q4 from inside the fly of the uniform pants, the DNA quantification results showed the presence of low levels of male DNA in both items, which made male DNA concentrations of 0.0102 and 0.0117 nanograms per microliter. Don't try to figure out how small that is, folks. It'll drive you crazy. And a ratio of male to female DNA of 1:20 and 1:21, respectively. This is actually the report. I don't know if that report exists anywhere because I don't think the one that I have is the qPCR report. SD14 choose. Oh yeah, it is. So it's referring to this chart right here. So yes, looky right here. XY. The forensics analyst should have known there was male DNA in items Q3 and Q4 because she herself initialed the page on which the male DNA data appeared in plain view in a column labeled quantity male. And I don't think that appears on this one, does it?
It's there. The initial is there.
No, I know the initial is there, but I'm looking for the quantity male column, and the copy of this chart I have doesn't have that.
Oh, gotcha. Okay.
But yes, if you look at the report, there's an EMT. Isn't that an oxymoron? Right next to her name in the report. Yeah, see, I'm not seeing that quantity male column on the copy that I have. We dispute the state forensic analyst testimony that Mr. Holtzclaw could be excluded from all 4 DNA samples from the fly of the uniform pants. When the prosecutor asked, so even though Officer Holtzclaw was wearing these pants, his DNA is not inside of them, correct? And the forensic analyst replied, that is correct. How do we know? How does she know that? The only area she tested, there again, was that small area by the zipper. She didn't test anywhere else on them. She didn't test anywhere else inside of them. How does she know?
Yeah, it does make sense to me. I mean, if you don't have a control, how can you possibly definitively say anything, honestly.
Yeah, but look at how he worded the question. Even though Officer Holtzclaw was wearing these pants, his DNA is not inside them, correct? He didn't say on the inside of the zipper where you tested. He said not inside them. She didn't test anywhere else.
Right.
He
Yeah.
didn't word it. He did not word it asking inside them where you tested. He just said inside them, which
Right.
leads the jury to believe that, oh, gee, she checked all inside those pants and his DNA was not anywhere on them. That's strange because they took him off his body.
Yeah, that's why you're better at this than me. It's not something I had really focused in on.
Her subjective statement showing 100% certainty that Mr. Holtzclaw was excluded as a contributor to the 4 DNA examples is an example of an error frequently made by expert witnesses. Well, first of all, I would not call her an expert. Which is to overstate the probative value of the evidence and go far beyond what the relevant science can justify. The exclusion of Mr. Holtzclaw as a contributor to the DNA samples from the fly of the uniform pants was wrong for 4 reasons. Forensic
Let me
analyst.
just really
Go
quick.
ahead.
Sharon, they didn't test anywhere in the pants or outside of the pants except for the zipper.
Yeah.
So she can't, so for her to say that, or claim that there wasn't any is just a blatant lie because she didn't test it. There was no control taken, no control tested.
And where there was low levels of male DNA, she didn't run the proper test to analyze it either, which is this blue area coming up. The forensic analyst never used YSTR profiling to analyze the male Y chromosome DNA variations in 17q3 and 17q4 and to determine whether they could have derived from Mr. Holtzclaw. The allele data were inconclusive as to whether Mr. Holtzclaw could be excluded or not from the 4 DNA mixtures, which had numerous alleles below the stochastic threshold, meaning that one cannot assume their sister alleles from paired chromosomes were detected during testing. That goes back to her arbitrarily setting that random threshold. Conclusively excluding Mr. Holtzclaw as a contributor to the 4 DNA samples was incorrect because when analyzing DNA mixtures from more than one individual where some alleles are below the stochastic threshold, one cannot know the complete DNA profile of every contributor due to the possibility of allele dropout or drop in caused by stochastic effects in PCR amplifications. PCR, the first time people heard of PCR, if you're old enough to remember back to the O.J. Simpson trial, PCR was one of the first genetic tests that were used in forensic. All the DNA they discussed in the O.J. trial was all based off of PCR testing. With low DNA quantities, the possibility of significant allele sharing among individuals and the possibility of contamination by alleles from environmental background DNA Goes back to what I was explaining with the chart. Every person on this earth shares 99.9% of the same DNA. Calculating the weight of evidence toward exclusion of DNA from Mr. Holtzclaw or any of the complainants from the Ford DNA mixture for which dropout allele was a possibility can only be carried out by using a probabilistic statement such as a likelihood ratio, which was never utilized by the forensic analyst. Okay, there were low levels of male DNA. What's the possibility that it could be Daniel Holtzclaw? 1 in 25, 1 in 35, 1 in 40. Okay, it's still possible. How many males did he come in contact with that night when he was on duty wearing those pants? I don't know the number, but for argument's sake, let's say it was 14 of them. All you have to do is go and look at his call record for that shift. And you know how many males he came in, male suspects at least, he came in contact with. So let's say he came in contact with 12 male suspects. What's the ratio of it possibly being him? Well, 12 suspects plus him is 13, so 1 in 13. That's not a real big ratio, a possibility. You know, we know the one guy that he interacted with on that shift was with 2 women. So at least in that interaction, there's the only possibility of one other direct male contributor.
And I believe, does it say at least 3 males? Is that?
Well, there's 4, but assuming one of them is Daniel.
Right, right. Yeah.
You know, that leaves 3 other possibilities. I believe one of them is Rocky.
Yeah. Yeah. Yeah,
So
absolutely.
that leaves 2 more. Now they get down to the samples that were taken in 2014. Remember, these ones they're talking about up here were the ones that were taken a year later. Q1 and Q2 were the initial ones taken in 2014. Those were complex mixtures defined of mixtures with more than 2 contributors that superimpose multiple DNA profiles for which alleles may be missing or may overlap. Okay, we're going to go back when they're talking about missing or overlapping. They just didn't detect that particular allele, but when they're talking about overlapping, all these green circles where all these people have the same number, that's what they mean by overlap. Those matches of that number can be explained by overlap. They both naturally have that particular allele in their DNA. Such that examiners must ask what the probability is that an individual's DNA profile could be present within the mixture rather than use an inclusion-exclusion approach. Basically, they're saying is, we know they had Daniel's claim DNA. We know they did. what they're saying in that particular paragraph is, hey, look, you have his full, complete, all 23 chromosome DNA profile. You've got a clean profile that you know is just him. There's no possibility of anybody else's DNA being mixed in there. You take that and you compare it to the mixture, and if you find some alleles in there that match any in his full profile, there is a possibility that some of that mixture is him. They never admitted to that. Yeah, everyone sheds, Liam, but remember earlier I talked about what we classify as a good shedder, an intermediate shedder, and a poor shedder. You will come across what are classified as poor shedders that maybe 1 in 10,000 times they touch something will shed DNA that might be detectable. A lot of people, you never will detect it. You would have to get the exact perfect item they touched. Yeah, it could. Absolutely, it could. Considering they were his uniform pants, I'm pretty sure that I mean, my guy, he was put them back on after wearing them for an entire shift, and then got in the car and drove into the station and sat there in an interview, wiped his hands all over him because he was nervous. I have absolutely no doubt that he shed some DNA on those uniform pants. Item 17Q1 may have derived from at least 4 individuals due to the presence of 7 alleles at one locus. So we know, based on the number of alleles on that locus in the results, that there was probably at least 4. There is some debate in the forensic community about using likelihood ratios for 4 or more contributors. Yeah, once you get a mixture over a certain amount, it makes it so difficult to separate the individual profiles that likelihood ratios really aren't any good. I mean, if you are trying to separate out a mixture with a likelihood ratio of, you know, 1 in 25, you're never going to do it. The best you would be able to say is it might match that individual. Okay. However, some laboratories calculate likelihood ratios for such mixtures using specialist probabilistic software that can take into account the stochastic effects and peak imbalance. So there is some pretty complicated software out there that can help you try to figure it out. Oh, but look here. The OCPD lab did not use or attempt to use the appropriate software. Oh. There again, don't run a test you're capable of running to exclude the subject you're going after. The forensic analyst's testimony excluding Mr. Holtzclaw as a potential contributor to DNA mixtures was therefore an error because it was based on a subjective assessment rather than an objective one. Subjective analysis of complex DNA mixtures has not been established to be foundationally valid and is not a reliable methodology. Number 3, even on a subjective basis, Mr. Holtzclaw could not be excluded as a contributor to items 17Q1 and Q2 because the majority of the alleles present in Mr. Holtzclaw's DNA profile, including sex chromosomes, are present in both items. The number of alleles in common with Mr. Holtzclaw equals 27 out of 32 alleles in 17Q1 and 22 out of 32 in 17Q2, all bet at a low level. So there wasn't a lot of it, but it was there, and it matched 27 and 22 respectively out of 32. Similarly, Mr. Holtzclaw's DNA could be present in DNA items 17Q3 and 4 at a low level as a minor contributor because these mixtures contained 19 and 21 alleles matching those of Mr. Holtzclaw, respectively, out of 32 alleles in total. So, 27, 22, 19, 21. All 4 of those numbers are over half of 32. So, his profile matched over half of the 32 alleles in all 4 samples. But according to the forensic analyst, he was excluded.
That doesn't make sense to me. I mean, I keep going back to when somebody's life or freedom is on the line.
Yeah.
Yeah, it's too much. I just,
The forensic analyst should not have excluded Mr. Holtzclaw as a potential contributor at items Q2, Q3, and Q4 during her testimony because this erroneous conclusion conflicted with her own OCPD forensic examination reports, in which she stated correctly that in item 17Q2, the minor component is not suitable for comparison purposes due to insufficient data. And in items 17Q3 and Q4, the minor contributors were not suitable for comparison purposes due to insufficient genetic material. In other words, she said in her report, there's not enough there to say for sure one way or the other, so I'm just going to exclude him. No.
I would think it would need to be the opposite.
Exactly, it's the opposite. Oh, wait a minute. There's some that match, so... But there's not enough to say 100% sure it's him, so I can't exclude him, but I also can't confirm it is him, but there is possibly DNA from him there.
Right.
Such statements mean that the results are inconclusive, being insufficient to clearly exclude or not exclude an individual's profile. The honest way for her to have answered that on the stand would have been, there was not sufficient DNA material there for me to say one way or the other. It could have been his, it could have been somebody else's, or conversely, it could have been somebody else's, or it could have been his. There just wasn't enough there to make a quantitative conclusion. That would have been the honest answer. But no, what did she do? She went on the stand and went, oh no, I can exclude him. None of it's his. Keep safe, Tony. Hey.
Thank you, Tony. Thank you so much for being here, for your comments and your contribution, and for the gift of membership, and for being a member yourself for 5 months. Have a great night. Stay safe.
And here we go. Here's another standard and procedure. The forensic scientist testimony excluding Mr. Holtzclaw from being a potential contributor also contradicted the OCPD DNA laboratory STR interpretations procedure manual guidelines issued 11/17 of 13. Those guidelines were there at least a year before this all came up. She should have known. She absolutely should have known.
But don't
Keep
you think
safe,
that
Sharon.
she did know? Yep. Have a great night, Sharon. Thank you so much for all of your contribution and your donation, and for being interested in the case. I am thrilled that you are finding it interesting and as horrific as I do. But be safe and have a great night. See you later, Sharon.
The
I'm
only
sorry.
way to know for sure whether or not she knew about those guidelines, a lot of, especially in the medical field area, a lot of different parts of the hospital or lab have what's called a communication book, and that's where whoever oversees the lab goes and writes a note for all the staff to read. So, and I had one when I ran the operating room at Fort Riley, Kansas, when I was in the Army. You know, I would put in there for all the OR techs, go read updated regulation 170-2 regarding whatever that regulation was regarding. When you have done that, initial. So they would go and pull the regulation book off the shelf where we kept them. And normally there were regulations about patient care and charting and documenting and stuff like that. But I would put inside the front cover of the regulation book a piece of paper with everybody's name on it. You know, they would be listed and then they would initial beside their name. That way, instead of chasing everybody down and going, did you read it yet? Did you read it yet? Did you read it yet? I can simply go pull the book off the shelf, open it, pull that page out and go, okay, all right, these two OR techs haven't read the regulation yet. I need to make sure they get that read as soon as possible.
Rick, I've been a manager or supervisor of every job I've had in my entire adult life. I'll just use the most opposite position of an operating room or something like that. As a manager or supervisor in various positions that I held at Walmart, I used to do the same thing. I used to make, if there was one specific thing that I needed to make sure everybody read, understood, and knew how to, you know, do, or whatever the case might be. And this is just at Walmart. I would do the exact same thing, and they would have to initial it. What I used it for, because I was running into problems where people were like, oh, I didn't know, oh, I didn't read it, oh, I didn't see it. They were held accountable if they had to read it, and they had same thing, and they had to initial it. Then they can't come back to me later and say, when they fuck that up, oh, I didn't know, because I'm showing right here that you did know, because you signed that you did, that you read it,
Well,
and that you
you're
understood.
you're excluding the possibility that they just went to where they signed it without ever actually reading the document.
Exactly. And if that's what they did, and they screwed
Well,
up at some
now we
point,
have a whole different situation. Yes.
yeah. Oh well, yeah. Then they're depending on the circumstances, they could be terminated. But that's just how basic that is, in my opinion. I did that with my associates at Walmart. And then, of course, I worked at the state mental hospital, and then I was a house manager for. The best way to describe it is kind of like group homes for disabled people. I was a house manager there as well, and I did the exact same thing. And depending on the situation, they would have their next shift to complete, to read or complete or do whatever it was, and initial it before I started hounding them. Because at the end of the day, whatever mistake is made is going to come back on me, and I'll be damned if I'm going to be held responsible for something that I had communicated with my subordinates, and they screwed it up for me. No, 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 no. You're going to get held accountable. I don't care if it's Walmart or the state mental hospital, or house manager for disabled people. I'm not going to be held accountable for something that you claimed, that you signed, that you had read or performed, or whatever the case was. So
Yep.
anyway, yeah, it's just
Oh,
it's just illogical to me that wouldn't be a thing in a crime lab.
you would think it wouldn't be a thing, but now, what does that guideline say? Some may ask. That guideline states that an inconclusive conclusion is to be arrived at where there is, quote, insufficient data, mixtures of DNA from multiple donors, or stochastic effects resulting in allelic dropout, which were issues with the DNA samples. All three of those things were true about those DNA samples.
Right. Yep.
She wasn't even supposed to use the word excluded. According to their guidelines, the only description she could use was inconclusive.
Yeah.
The state's forensic analyst displayed lack of awareness that touching an item may not deposit one's own DNA. She actually claimed that the absence of Holtzclaw's DNA was very difficult to try to explain. Well, there's two problems with this. Yes, point number 3 is correct. If you're a pore shedder, it's possible that you could touch something and your DNA not be on there. But here again, this is the 5th or 6th time I've said it during this presentation. She never tested anywhere else on the pants. Very easy to explain why you didn't find any of his, because the area you tested was inconclusive and you didn't bother to test anywhere else. It's a very simple explanation. It's not difficult. But of course, you can't admit to the jury that you never tested anywhere else on the pants. That statement was, in their opinion and mine too, was used to support the prosecution's argument that Miss C1's DNA was unlikely to have transferred innocently via Mr. Holtzclaw's fingers. The forensic analyst ignored scientific research available before the trial that proved people can transfer someone else's DNA that's on their hands without transferring their own DNA to objects they touch. She also ignored research revealing that people do not always transfer their own DNA, wearer DNA, in detectable levels to their own clothing or to touched objects, and even repeatedly touching an object does not necessarily deposit DNA. There was a low threshold of male DNA in all 4 samples, but there wasn't enough to determine who it was. Doesn't that sound kind of like what that study they're talking about found? Studies of people's shedder status reveal that some individuals at various times do not readily deposit their own DNA, which could account for not finding all. I like the way they worded this, not finding all of Mr. Holtzclaw's alleles in the 4 samples from the fly of the uniform pants. Because remember, over half the alleles they found did match him in all 4 samples. The state's forensic analyst did not testify clearly about the presence and implications of DNA from at least one male. If the non-semen DNA mixtures from several unknown individuals, including at least one male in the 4 samples from the fly of the uniform pants, have been reported and discussed thoroughly by the prosecution and trial defense attorney, then these results would be expected to have undermined the prosecution's argument that sexual assault was the most likely explanation for the discovery of DNA matching Miss C1's profile on the outside and the inside of Mr. Holtzclaw's uniform pants. The implication of finding male DNA is that it demonstrates an individual's DNA can transfer to the fly of the uniform pants without any involvement of that individual's vaginal fluid, since males, surprisingly enough, do not make vaginal fluid. Furthermore, yeah, I know, shocker.
After raising 5 boys, and I don't know that.
Yeah, spoiler alert for any of those of you that don't have male kids. Spoiler alert. Furthermore, it's expected that male DNA in item 17Q1 came from at least one male who is not Mr. Holtzclaw, based on the strength of the Y chromosome allele and the fact that Mr. Holtzclaw could not definitively be included in this mixture. That's where the unknown male comes in. Yet the method by which this male DNA transferred was not investigated, even though it could be the same method by which DNA matching Miss C1's profile transferred to the fly of the uniform pants. They never even bothered to look how it got there. Oh, well, there's male DNA there, but we can't say it's Daniel's. It could be somebody else's. Gee, how did another guy's DNA get there? Maybe we ought to look into that. No. Our victims are all women. We don't need to know how it got there. And I'm going to take a pause here for just a moment, ladies and gentlemen, because my bladder is screaming at me. Give me about 3 minutes.
No problem. It's definitely been a long little run. Hence, you guys are stuck with me. Am I, as Liam says, yeah, I completely agree, Liam, with that. And I say that all the time. There was so much information. And by the time, they got to, well, I can't remember where it was in the trial, actually, when she testified overall about the DNA. Well, she testified as to Adara Gardner, so the 17-year-old. So I believe that was where the largest portion of her testimony was, Elaine Taylor's. And so I'm really appreciating Rick, breaking this stuff down the way he is, because I mean, when I've read this, I've read it and just kind of, I haven't really, taken apart, which is something that's, maybe I've actually become better at it since I read this. But words and phrases are like things, those are my things. Those are the things that I focus on, are words and phrases. And of course, the first time I read this, I was I had no, I don't want to say knowledge or understanding, but no education maybe about DNA and forensic evidence and that kind of stuff. So, some of these things that he's pointing out, pay attention to this phrase or pay attention to this sentence or word or whatever. Rick pointing them out today is the first time I've ever considered some of these things. And it's making it even more of a big deal about how not poor, but how corrupt or unethical or flat out dishonest, untruthful the testimony was regarding this DNA. So, good. Rick didn't take long. Men are like that, from my experience. I'm going to put him back on, and I'm actually going to take a quick break myself, but I'm going to have Rick continue, if that's okay.
Mm-hmm. Okay. During the trial, the prosecutor and the state's forensic analyst never overtly disclosed the presence of at least one male contributor in the DNA samples, nor did defense counsel observe there was male DNA in the samples. They just never bothered to say. They just never bothered to say. If I was the defense attorney, as soon as she testified that she could exclude Daniel from the DNA, as soon as I cross-examined, my first question to her would be, in this column on your report, it says there's a quantity of male DNA present. How can you exclude him? The prosecution never brought it up. The defense attorney should have immediately. As previously explained, the forensic analyst claimed incorrectly that there was no evidence of male DNA in items 17Q3 and Q4. She also never testified overtly that male DNA was found in item 17Q1 and close to equal proportions with the female DNA, indicating approximately a ratio of 1/2 male to 1/2 female in this sample. The forensic analyst also dismissed the importance of the Y chromosome in item 17Q2, simply testifying that X is in black and the minor contributor is a Y. But it's in red, so it really basically doesn't count. Oh, I wrote it in a red font, so it really doesn't mean anything. Ignore the red parts, they're not important. The statement that best suits the minor contributor is that it is not suitable for comparison purposes. Well, at least she was kind of honest about that. That's the closest she came to saying the word inconclusive. The prosecutor misstated the DNA evidence during closing, as described in Mr. Holtzclaw's brief. The prosecutor fundamentally mischaracterized the forensic evidence. I put all of this in red. I'm not going to bother to underline it because this is all extremely important. When he claimed it was a quote unquote fact that Miss C1's DNA, quote, from the walls of her vagina was transferred in vaginal fluids onto the outside and inside, not of his pockets, not of his cuff, not where he sits, but the exact location she says his penis came in contact. This statement was not a scientific inference because of a basic tenet of science is that one cannot claim the presence of a substance for which one has not tested. And specific biochemical confirmatory tests are required to associate a biological fluid to DNA evidence. This goes back to they only tested the area around the zipper. Well, yeah, he's saying that none of her DNA was anywhere else. Well, the reason he can say that is they never tested. Except he really can't say that if he was being ethical because they never tested. He doesn't know that there's none of her DNA in any of those places. He doesn't know if there is. He doesn't know if there isn't. Schrodinger's cat. Cat inside a closed box. The cat is both alive and dead until you open the box. The prosecutor also misled the jury by implying that finding DNA only on the fly of the uniform pants and nowhere else was especially incriminating when he knew full well that only the fly was tested because he himself, pay attention to this, let me change another color here because this is very important. He himself had requested that the lab specifically analyze the inside crotch area of the pants for female DNA, as stated in the OCPD Lab Services Division request for analysis form. Giger's the one that told them to limit the area they tested. No. Don't test the inside and the outside everywhere. Just test this area right here. Court opinions. These aren't guesses. These aren't an academic sitting and going, oh, I think this is the way it should be. Court opinions emphasize a particular harm caused by prosecutorial misconduct involving DNA evidence. That's exactly what Giger engaged in. Prosecutorial misconduct. He lied about the evidence. He instructed the lab to limit the evidence that they obtained. The DNA evidence from the fly of Mr. Holtzclaw's uniform pants and its mischaracterizations were likely to have a large prejudicial effect and therefore impact the trial verdict because jurors overvalue DNA evidence, especially when a DNA match is found in weak circumstantial cases such as Mr. Holtzclaw's. That's that comprehension bias again. Watching all those shows on TV, oh, the DNA evidence has to prove that he did it because it always does in these shows. DNA can never be wrong. We are concerned that the harmful impact of the DNA evidence errors runs much deeper to the heart of the trial because the state obtained most of its evidence against Mr. Holtzclaw by building a biased investigation upon the OCPD forensic analyst's flawed conclusion that sexual contact best explained the evidence. I think they're being generous. I don't think that was the sole reason why they built that case. I think it was a large part of it, but I don't think that's what caused the bias. I think they were told by the lieutenant, go get somebody.
Well, and I agree with you, Rick. And I think that was propelled or perpetuated or began when Janie Liggins went to the media 4 days after this whole thing started. And Black Lives Matter was really,
Yep.
A big deal at that point. There was already a lot of unrest across the country. This was before Ferguson, but there was already, you had George Zimmerman and everything.
Yep.
And when Janie Liggins went public like she did, I'm not excusing them, but in their sick, twisted, unethical minds, they thought we got to do something now. We got to make a deal about this, or we're going to get crucified in the court of public opinion.
Yeah, I've said it before. You watch the media coverage and the pronouncements by the detectives and the prosecutors. They all describe Daniel as a white police officer. He's Oriental. He's not white. He's Oriental. He's not a Caucasian. I keep looking over at the screen because I can see your face on there and my camera is over on this one. It looks like I'm ignoring everybody. Jurors likely place enormous and excessive faith in DNA evidence, such that it would have an unduly large influence on their verdict. There again, this goes back to confirmation bias. This panel describes it as an aura of infallibility. The DNA evidence in Mr. Holtzclaw trial, despite its low probative value, is also expected to have been heavily valued by the jury because the complainants had severe credibility issues. They were career criminals, they were drug addicts, they were prostitutes. The additional circumstantial evidence was weak, and 2 jurors stated publicly that the DNA evidence was crucial in the jury's deliberations. Research shows that jurors often overvalue the weight of DNA evidence, even when it lacks probative value. And they'll talk about the studies here after I post this. You can go look up the studies. And if you want to see the studies, let us know, because Rhonda has a hard copy. Well, I have a hard copy of this too. I can always get you the name of the study. Even when DNA evidence is of little or no probable value, it carries a disproportional weight compared to other types of evidence considered by jurors. Jurors have been found to place heavy and perhaps disproportionate reliance on probative value of DNA, an advantage that has pre-trial origins such that the prosecution is at a unique advantage by means of its simple introduction. I have been of the firm belief for a very long time that even at the local district level, the court that's going to try the case initially, before any DNA evidence goes before a jury, there should be an evidentiary hearing where the defense can bring in their own witnesses so the judge can rule whether the jury ever hears it or not. Otherwise, you have prosecutors that pull this crap. And that's easy to do. Write it into the Judicial Procedures Handbook. If DNA evidence is going to be introduced at trial, an evidentiary hearing must be held before preliminarily. Studies of mock jurors reveal that some have a pretrial pro-prosecution bias that forensic evidence is nearly infallible and conclusively identifies the guilty party, and this bias, which can be measured by the Forensic Evidence Examination Bias Scale questionnaire, makes jurors more likely to ascribe higher strength to weak, ambiguous DNA evidence and convict the defendant. They're going to cite another mock jury trial study here. It's basically saying the same thing. The DNA match to the teenager, Miss C1, was the linchpin in Mr. Holtzclaw's trial, not only because jurors tend to give DNA evidence more weight than its due, but also because all of the complainants had significant credibility issues, and the governance evidence was circumstantial and weak due to the prosecution's heavy reliance on imprecise, inaccurate, and inconsistent patrol car AVL data that proved Mr. Holtzclaw had interacted with the complainants, yet was not proof of sexual assault. For anybody who has watched those videos, those are the maps with the lines, and I can't remember if they're dots or arrows with times showing where the car was close to on a street at various times during these supposed incidents. The DNA evidence was pivotal in the trial because the 13 complainants had severe credibility issues, including drug use, psychiatric problems, criminal arrests or convictions, inconsistent testimony, or a combination thereof. Not only the 5 women whose allegations led to acquittals had such issues, but so did the 8 complainants C1 through 8 described below, whose allegations led to guilty verdicts. We've covered a lot of their inconsistencies and stuff and their statements in other videos, so I'm not going to go through a rehash of all the things that they said. Actual juror comments reveal the prejudicial impact of the DNA evidence. The prejudicial impact of the DNA evidence in Mr. Holtzclaw's trial is shown by the comments of 2 jurors who spoke to the press in post-trial interviews. Both expressed that the DNA evidence swayed the jury toward guilty verdicts. Juror Ron Hill said in a news interview that the DNA evidence was very crucial. Rhonda, do you have these YouTube links in a format that they can be put in the chat?
I'm getting them right now. If I don't, I'll put them in the description.
Okay. Similarly, as reported by the press, at first, juror Daniel Speaks said a number of jurors were ready to set Holtzclaw free because they didn't believe some of Holtzclaw's accusers. There was some jurors that, due to the fact of who these victims were, had a hard time believing them, Speaks said. Speaks says that it was the DNA evidence on the inside of Holtzclaw's pants and testimony involving a 17-year-old victim that helped get the deliberations moving. Juror Daniels Speaks also revealed to Crime Watch Daily that he believed the DNA had transferred in vaginal fluid because the jurors were told this during trial, demonstrating that the jury was misled by the prosecutor's false claim that the teenager's DNA transferred in vaginal fluid. To quote the juror, well, I mean, I'm not a DNA expert, shrugged shoulders. They told us it was DNA from the vaginal fluid of a 17-year-old. The DNA people are pretty boring, to be honest with you. They were also pretty unethical. Young man, you just didn't know it at the time. DNA analysis errors and misrepresentations are especially harmful because jurors weigh DNA evidence heavily. This is just talking about another study in a court case that happened because of the misuse of DNA. Basically, what it boils down to is because of the widespread belief that DNA evidence is reliable, prosecutorial misconduct related to DNA evidence can't be tolerated. We should have zero tolerance for prosecutors manipulating forensic DNA information. As far as I'm concerned, Giger doing this alone should be grounds for disbarment. Courts have repeatedly found a prosecutor's misrepresentation of forensic DNA evidence to be reversible error. And they cite the case. Duncan 322 Southwest 3rd. If you want to look that up, you can. There's another one, WAC 73 A3D. They cite a bunch of cases here. I have looked up some of them. The one that I find the most relevant is People v. Wright, 25 New York 3rd. That's a particularly relevant one if you want to look it up. And this is specifically why reversing a conviction where prosecutorial misconduct occurred during the closing argument and defense counsel failed to object time and again when the prosecutor repeatedly misrepresented to the jury critical DNA evidence as proof of the defendant's guilt. The DNA analysis errors that misled the jury in the trial were highly prejudicial because they encouraged jurors to dismiss as unlikely the explanation of non-intimate DNA indirect transfer and to give more credence to the allegations, not just of Ms. C1, but also of the other women, even though they had credibility issues and no forensic evidence supporting the allegations. As noted in Mr. Holtzclaw's brief, errors may give support to other less reliable evidence, making the other evidence seem more reliable. If the prosecution in Mr. Holtzclaw's trial had not misled the jury by misrepresenting the probative value of the DNA evidence, the trial outcome would likely have been different because the jury's verdict rested heavily on the DNA evidence. The misrepresentations and incorrect arguments concerning the DNA analysis were harmful in light of all the evidence because the state built a biased investigation upon the foundation of the mischaracterized DNA evidence. This goes back to her. Basically, what this is going in more detail about is the forensic lab going to detectives and going, we've got female DNA and it doesn't match the person who filed the complaint. But it had to come from vaginal fluid. So they start looking. The prosecution's forensic science omissions and inaccuracies and defense counsel's ineffectiveness at exposing and correcting them were harmful in and of themselves, compounding each other and causing the DNA evidence to appear more incriminating when it could be explained by non-intimate indirect DNA transfer. Yet the incorrect conclusions and arguments about the DNA evidence also impacted the entire trial and were far from harmless in light of all the circumstantial evidence, because most of this of the evidence in this case was obtained through a biased investigational process founded upon the forensic science errors, which inspired detectives to use leading interview techniques to solicit many of the complainant's allegations. We got a tip. The state's investigation was driven by the forensic analyst's unscientific advocacy for the presence of vaginal fluid as an explanation for the discovery of DNA matching Miss C1's profile. The forensic analyst's unscientific opinions are expressed concisely by the state of Oklahoma itself in its witness list provided October 5, 2014, which describes her proposed testimony as follows. She, quote, will opine for C1's DNA to be transferred to the pants. It most likely was contained in some type of body fluid, including vaginal secretions or saliva, and she will express opinions that defense's assertion that C1's DNA was found inside his pants as a result of contact DNA transfer is not reasonable and perhaps not even possible. In support of this conclusion and opinion, she will testify that defendant's own DNA was not even found on his pants. We know that's a lie. She doesn't know. She only tested that one area. His DNA could have been all over him. The forensic analyst, forensic science inaccuracies, and incorrect testimony appeared to have risen from or contributed to her pro-prosecution bias that is clearly demonstrated by her testimony that, unfortunately, in this case, like how she worded that, unfortunately, in this case, Mr. Holtzclaw's DNA was not found in Miss C2's sane kit. Think about the way she worded that for a minute.
Well,
What do the words in this case infer?
Also the word unfortunately, well, maybe this is the wrong part I'm thinking about that word. Unfortunately, in this case, Mr. Holtzclaw's DNA.
No, you have to take all four of those words together.
Yeah. Oh, yes, for sure. Unfortunately, in this case. Right.
Now, if you're a juror and you hear, unfortunately, in this case, Mr. Holtzclaw's DNA was not found in Miss C2's sane kit, what exactly, Liam? It implies that there's another sexual assault case out there where his DNA was found.
I don't like the word unfortunately. Why is it unfortunate that his DNA isn't found? Well, I mean, I get the bigger picture of it.
Yeah,
obviously.
She's trying to infer that there are other cases where it was found that are sexual assault cases.
But unfortunately, not in this one.
Specifically that way. I have no doubt she worded it specifically that way for a reason.
Yeah. Well, yeah. It creates even unconscious bias.
Yep. Such emotional bias has the potential to create cognitive bias, which refers to ways in which factors unrelated to decision-making task can shape perceptions and judgments, affecting the reliability of conclusions. When forensic experts are affected by cognitive bias, it is especially harmful because juries and judges trust them to provide impartial, objective, scientific truth. Cognitive bias is an important cause of DNA analysis mistakes and leads to the very sort of subjective pro-prosecution errors that appear to have occurred in Mr. Holtzclaw's case during DNA testing, DNA mixture interpretation, and testimony. Examples of the forensic analyst's cognitive bias are that she overlooked the male DNA in 3 and 4, and she subjectively and incorrectly excluded Mr. Holtzclaw as a contributor to all 4 DNA mixtures. These pro-prosecution errors made the DNA analysis results appear consistent with the forensic analyst's opinion that an absence of Mr. Holtzclaw's DNA meant it was a very good possibility that Miss C1's DNA transferred in her vaginal fluid. This study is a good one to read, DNA Evidence, The Myth of Infallibility. And just the quote they took from the article, which I think is very on point to Daniel's case, is the most common form of misconduct in DNA testing is shading of scientific findings to make them more coherent and more consistent with what the analyst believes is true. Not what the analyst finds to be true, what they believe to be true beforehand, before they've ever tested a single thing. The state then assumed that only sexual contact would transfer a woman's DNA to the fly of Mr. Holtzclaw's uniform pants without considering the possibility of non-intimate DNA transfer. I got news for you. The detectives had already decided that he was guilty before they even collected his uniform pants and belt for evidence.
Oh, definitely.
This is shown when the prosecutor told the trial judge at a motion hearing on October 2nd, 2014, before Ms. C1 had been identified. Pay attention to that. Before Ms. C1 had been identified as a match. When did they take those second samples? Oh, that's right, 2015. That it was an undeniable fact that there is at least one more woman out there because we have her DNA and that he has had sexual contact with. And we still don't know who she is or where she is. He'd have looked like an idiot saying that if they'd have found her and she went, "Oh no, he didn't sexually assault me. I got knocked over by some idiot on a bicycle and the nice officer helped me up and helped me pick the things up that I dropped and made sure I was okay." Without even knowing who she was and interviewing her. The prosecution is telling the judge in a pre-trial motion hearing that, oh no, he had sex with another woman. We just don't know who she is yet. He had no way of knowing that. He lied. Finally, the detectives assumed that the DNA evidence was incriminating, as shown by the female detective's testimony that the unknown female profile was significant because the detective thus knew we had another female out there, someone Mr. Holtzclaw hadn't told us about, implying that Mr. Holtzclaw withheld information. Oh, he had to have sexually assaulted somebody. We just haven't found him yet. he didn't tell us about him. He's trying to hide it so we can't get him for that one too.
Oh, well, and I have to, and I keep saying this over and over too. The detectives and Giger and whoever else imply that Daniel withheld names and this and that and contact with who and what. They only ever had one interview with Daniel, and that was on June 18th, 2014, in the interrogation video. After that, Daniel's FOP representative declined to let him speak to investigators any further.
Smart
So
rep.
Well, yeah. Unfortunately, he didn't invoke that at the very beginning, but that's another topic altogether. But for them to imply that Daniel didn't tell them about this or that, or the only person that they spoke about in the interrogation video was Janie Liggins, and then about 3/4 of the way through or half of the way through, Rocky Gregory brings up Terry Morris, which is, again, another whole topic that I'm not going to start tonight. But anyway, so for them to imply during the trial or anywhere else that Daniel, that they had other conversations with Daniel and that he withheld stuff, that's just complete horseshit. Just putting that out there.
Oh, yeah, absolutely. The hunt for the unidentified female then propelled the investigation. To be clear, searching for the female who matched the DNA profile on the mixtures obtained from the uniform pants was not the error. The state's investigational error was to assume that only sexual contact could have resulted in the DNA evidence, and that female DNA evidence on the fly of the uniform pants was incriminating. To assume, as the lieutenant did, that African American women with warrants, racist much, and criminal histories were targets based on 2 complaints, the former lacking warrants and convictions. There was one supposed victim who had no warrants or convictions. All the rest of them they went after dead. And to allow flawed assumptions to cause detectives to use leading interview messages when soliciting testimony from the chosen women, telling them that the police had, quote, received a tip, unquote, that the women were, quote, possibly sexually assaulted by an Oklahoma City police officer, unquote, and encouraging interviewees to help catch the, quote, really bad guy, because police had a long list of victims. Investigators in Mr. Holtzclaw's case appear to have succumbed to a type of cognitive bias called confirmation bias. I spoke about confirmation bias earlier in regards to the DNA, which is the tendency to search for and interpret evidence in ways that confirm pre-existing expectations or beliefs while failing to identify mistakes and missing or ignoring other important facts that contradict their hypothesis. We are concerned investigators developed tunnel vision, starting with an assumption of guilt based upon forensic science errors without considering other hypotheses, and then homing in on their suspect while missing or discounting exculpatory evidence such as the negative SANE kit for Miss C2 and lack of visible staining on the fly of the uniform pants, and working backwards from the assumption of guilt and literally pulling together an account of events that was based upon pure speculation. Many long, this is a study that they're basing this observer bias on. Many long, and the quote from that study, and it's a Savino and Turvey study. It's actually a very good study. Many law enforcement investigators work backwards. They arrest suspects first and then conduct biased investigations that are geared primarily at building a case against that suspect. Anybody who watches Robert Gavea knows the layman's term for that. Give me the man and I'll find you the crime. Not let me investigate the crime and try to figure out who did it. Give me a person and I'll figure out something they've done wrong so that we can get them. The bias of the sex crime detectives is revealed in their testimony as they repeatedly dismissed the discrepancies between complainant's allegations and the facts. The male detective left out his police interview report that Miss C12 answered 5 times that no officer had been inappropriate with her. When Miss C6 testified that her assailant was a black male shorter than herself, the female detective said in response to whether this discrepancy worried her that there's no lights out there at the school. I'm sorry. If you're in a dark area and your assailant is Oriental, you're going to see something as opposed to a black male who's darker than you. Anybody who's ever served in the military, there's a reason we wear camouflage paint on our faces at night. The moon and the stars can reflect off of your skin and you can be seen. Even though it would be expected that Miss C6 could discern whether or not Holtzclaw was black because she testified she could read the words on Mr. Holtzclaw's computer screen while he was running her for once in Warren's, and she sat in the back seat of the patrol car. Oh, so it wasn't dark. There was actually a light, the light from the computer monitor screen. When Miss C5 testified that Mr. Holtzclaw stopped his vehicle and picked her up on 24th Street, although the AVL location data shows his patrol car never went on that street, the female detective explained this discrepancy by saying her memory just wasn't correct on him driving down 24th. Oh, she was just confused about what street they drove down. Our AVL data shows the correct one. In contrast, when Mr. Holtzclaw did not log his stop with Miss C5, quote unquote, correctly on his handwritten activity card, the detective testified, I feel this was being deceptive. Even though Mr. Holtzclaw had called dispatch to notify them of the traffic stop. So you get on the radio and you call dispatch, which is recorded 24/7, and say, I'm out with an individual at such and such a location, but you check a box or you write something wrong on a card. You got it on tape, lady. Please, being deceptive. Being deceptive is not calling in and writing something else on a card. We are concerned that Mr. Holtzclaw's case is an example of how the forensic confirmation bias can corrupt the conclusions and testimony of forensic examiners, and then these conclusions, once corrupted, can have grave consequences influencing other lines of evidence, such that forensic science conclusions appear to corroborate other forms of evidence. The problem of the chain reaction of confirmation bias infiltrating an entire investigation has been observed to have relevance at the appellate level, where courts should not make the mistake of deeming flawed evidence in trial to be harmless in light of all the evidence that appears to support the conviction, when in fact the other evidence was not independent of the flawed evidence and actually arose or produced it. The forensic science errors in Mr. Holtzclaw's trial are harmful because they form the flawed foundation of the case built against Mr. Holtzclaw and created an unfair trial substantially swayed by error that led to his convictions. U.S. v. Bagley, where the court reiterated that an error is not harmless if there's a reasonable likelihood the error may have affected the jury's decision to convict the defendant. Their conclusion is basically saying we believe his convictions need to be overturned, and at a minimum, a new trial should be given. Rhonda and I think are in agreement that they need to be overturned and no other trial ever need happen. The first one shouldn't happen to begin with.
Yes, absolutely. Absolutely. Thank you so much for breaking that all down for us, Rick. I
Yeah, folks,
couldn't have
that
done it.
was, I started on that the day after the last stream, and it's taken me through, from then through Easter. I actually finished the last of what I needed to do for this about 3 hours before we started the stream. I've been working on this for 2 weeks.
And that was a Reader's Digest version.
Oh yeah, I could do a 3-hour class session in a university just on the problems in this case and how the DNA was used incorrectly.
Yeah. Hey, Mama Pillow, thank you so much for dropping in and checking it out. Yeah, Rick has done a really great job of breaking down, like I said, in a Reader's Digest version, pretty much, this Amicus brief. And I can't thank him enough. There's just no way I could. I felt like it was really important after we 3 weeks ago discussed the Brent Turvey, Susanna Ryan, and Dr. Crane video that we went through. And then 2 weeks ago when we talked about the series Secret Hearings, which is believed, I think, that the secret hearings involved, in part, regardless of I'll just say my opinion, because I can't put it on anyone else except for myself, but I believe that the secret hearings had to do with the testimony given by the crime lab analyst, Elaine Taylor. And I think that because, well, besides what the news video said about it as well, which we showed, I think, 2 weeks ago. But with the crime lab analyst, or the crime lab supervisor being a part of those secret hearings, they said that it was, it was all personnel matters apparently surrounding Elaine Taylor. And that, I mean, if that's all it was, then why are those records still sealed? Number one. Number two, with what Rick just ran through with everything, well, didn't run through it, but what he broke down for us, it makes it even more logical in my mind that that's exactly what they were talking about in those 2 days of secret hearings, was her testimony and the way she testified regarding the DNA in Daniel's case. And it seems if you're just, if you're from Oklahoma City back in 2014, 15, 16, 17, and all you're hearing is what the news is telling you, you have no idea what went on behind the scenes that Rick just broke down and explained to you. And he didn't even get to all of it, quite honestly, because I know there's so much more that's involved in it, and all the studies and case law in that amicus brief. Pardon me. I did put a couple, I think, of the different studies in the chat for you. I'm not going to put them all. I'm not going to do them all because there were quite a few, but Rick did mention a couple that he thought were particularly interesting that, he suggests that you read. But I think Rick said that he's going to put his version of, all of his markings and highlights and everything. He's going to download that and put it in Discord. So if you want to read Rick's entire what he went through in all the highlights and things that he's underlined and things that he's suggested that you read, you can check back in Discord sometime this week. I'm not going to have him do it right now, but I want to ask you this question, Rick. I love puzzles and I love strategy. I don't know if this falls into that category, but I'm wondering, since you have made your own chart based on previous presentations and things like that, your own DNA, I can't think of what it's called, chart is the only thing, with all of the breakdown of all of the alleles and the loci and all that stuff. I'm wondering if anybody else would be interested in looking at that clean, like you have it, with just the numbers and the highlights that you have of certain things. If people might want to look at that as well and download it for themselves and go through it all, and based on your highlights and everything else, come to their own conclusion of what all the DNA really said that didn't get presented or portrayed the way it should have. Do you know what I mean? Because that's something that I will do. That's something I would love to do, is to download that chart that you've made and do that myself, and just love the strategy of trying to figure it out on my own and making my own marks and this, that, and the other. So I don't know. If you're in our Discord, I dropped the link to that a little while ago. I'll put it in the description too. I didn't get any any links added into the description of the video today, but I will. That, you'll be able to find all those links there. But at any rate, I just, if everyone who's still here could just give Rick a huge virtual round of applause for the work that he's done in breaking down some of those words and phrases and technical terms that I certainly still am trying to learn to understand. we really appreciate it, Rick. And, um, and it was so nice to have, especially today, well, this last week actually, of not feeling well. It was really nice to have you, pretty much take the wheel on this one and offer your knowledge and your expertise. And I know everyone probably is very grateful to you for doing that. So we all thank you very much. So with that said, we've gone really, really long, and I'm sure Rick is needing a long break, rest of the night break, and I need to take something more stuff for my bizarre, outrageous headache and try to get some rest. So thank you all for being here in the chat, Jennifer and Under Your Scars, Tony Hay, Sharon Sunshine, and anybody else. If I've forgotten your name, that you made a donation or gifted a membership, thank you so much for supporting and just for being here and asking questions and making comments in the chat. That's a support that we appreciate, and I know Daniel also appreciates from the bottom of his heart. So, thank you guys so much for, especially all of you who are new, which is probably, I think, most of the chat that I can see right now. You guys are newer to this case, and the fact that you keep coming back is a great sign that you truly do care about justice, wrongful convictions, and truth. And, that means a lot to all of us. So thank you in the chat so much for all of your participation. Rick,
if you're on the Discord server, the my annotated Amicus brief PDF file and the illustrations PDF file are both now in DNA 411.
Perfect. Awesome. Thank you for doing that. He's so efficient and quick, and me, I would be like, okay, I'll get it in a couple days. Rick's not like that. He's on the ball. So I appreciate that so much. Pardon me. Rick, do you have any final comments or recommendations or suggestions or anything that you would like to?
Thank you,
Or have you done
everybody
enough?
who's stuck around. DNA stuff can be boring. I tried to make it unboring and tried to explain it in a way that you could understand exactly how corrupt the entire investigation was.
Yeah. And that's just it. And Rick, you hit on an excellent point. Rick spoke basically about the DNA in the case, such as it was or wasn't, but how central that was to the entire case. And I put links to I think I put the link to the 4-part article, or the 4-part the article, the Crime Daily News article or whatever, but it has all 4 parts of their mini doc that they did. But I also put in the video of Juror Speaks. His name is Daniel Speaks. I put in just that video news clip. And so if you want to go and look at those things on your own later, those are there for you as well. And I'll try to get those in the description as well. And I'll get that. I don't know how soon I can go in and edit the description of a video, but as soon as I can, I'll have those links all in the description for you guys too. So with all that being said, and all of the great information that Rick has provided to us, thank you guys again. And I don't know what we're going to do next week. I kind of want to go into the appeal itself. like the detectives, I'm working backwards. I'm kind of working backwards, from secret hearings to amicus brief to the appeal. But I think if we do the appeal next week, you will, I guess it wouldn't be an unbiased, hearing of the appeal or reading of the appeal, but you'll have maybe some more context to add to it that might be
Oh, a
useful.
lot more context. There's a ton of stuff in the appeal that I didn't even mention.
Yeah. The appeal itself is just ridiculous. And when you compare that appeal to what this amicus brief points out, makes, very, very clear. They don't use the word corruption because they're all professionals. I am not a professional, so I can call it corruption for my opinion. When you have that to contrast with what the appeal says, it's going to be even more irritating and angering and frustrating and almost unconscionable, how they broke down this appeal denial. So I kind of think that's what we're going to do next week, but I can't make a promise to that. But it's pretty much where my frame of mind is right now. So if there are no other comments from Rick or any other questions in the chat that we can address, we're going to go ahead and end it for this time. And until next time, peace out.